For judgment, item number 45.
For reasons mentioned in the judgment, this court is of considered opinion that in view of serious and glaring irregularities and shortcomings which have been mentioned in this judgment in conduct of the recruitment process for appointment of 61 numbers of the post of ANM/FHW in pursuant to the requisition made by the government to the NSSB, the sanctity of recruitment process has been compromised, and as such, entire recruitment process for the said post is liable to be set aside. This court therefore passes for following directions. The recruitment process initiated by holding the Combined Educational and Technical Service Examination 2023, so far as it relates to the appointment to 61 numbers of posts of ANM/FSW in the Department of Health and Family Welfare, as provided in item number 4 of the advertisement dated 15/12/2023, is hereby cancelled. Consequently, the list of selected candidates for Viva Voce, which were published on 22/5/2024 as well as 23/5/2024, are also squashed and set aside. The NS Nagaland Staff Selection Board is hereby directed to immediately notify the cancellation of the recruitment process for the 61 number of posts which were advertised in widely circulated leading local newspaper as well as in its own website. The respondent number 1, 5, and 6 are hereby directed to consider bringing necessary amendments to the Nagaland Nursing Service Rules 1988 so as to provide therein the educational/eligibility criteria for appointment to the post of ANM/FHW in an unambiguous manner This shall be done within a period of 45 days from the date of this judgment. After lapse of the aforesaid period, the respondent number 5 shall, within 15 days thereof, make a requisition to NSSP, strictly complying with the provisions of Regulation number 14 of NSSB Regulation 2020 for filling up the vacant post of ANM/FSW, which exists at the time of making such requisition. After receipt of the said requisition from the government, the NSSB shall issue necessary advertisement for the same within 15 days thereof, in pursuant to the provisions contained in Regulation 14 of NSPB Regulation. The candidates who had applied and participated in previous recruitment process for the post of ANM/FSW in pursuant to the advertisement dated 15/12/2023 may also appear in the fresh recruitment process. They shall have to apply afresh in pursuant to the new advertisement to be issued by NSSB as per the directions made in column 5 above. However, those candidates shall be given additional age relaxation for the period between 15/12/2023 and the last date of filling a form in pursuant to the fresh advertisement to be issued by NSSB as per these directions. The NSSB shall prepare a timeline to complete each phase of the recruitment process in conformity with the Part B of the Nagaland Staff Selection Board Regulation 2020. The said recruitment process shall be completed within a period of not later than 6 months from the date of issuance of the advertisement. With above observations, this writ petition is hereby disposed of.
For judgment, item numbers 46 and 47.
In both the cases, the petitioners are found entitled to get the provisional pension in terms of, as per the provisions of Central Civil Services Pension Rules 1972, which has been adopted by the state of Nagaland. The respondent number 2 is directed to immediately take steps for releasing the provisional pension to which the petitioners are entitled to in view of the discussions made in the judgment. The respondent are directed to comply with this judgment as expeditiously as possible, but in no case later than 3 months from the date of this judgment. These writ petitions are accordingly allowed.
Yes, Lordship. Lordship, I beg to mention items 39 and 40 from the hearing list. And 40. And then 40. Lordship, it's limited to about 3 weeks, Lordship. Lordship, my senior will conduct another hearing today, so in view of that, this matter wouldn't be able to take up, and moreover, he has some plans for traveling, so the matter travel for 3
Heard
weeks.
Mr. Foseco Forte, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. Also, Mr. Imtim Song, learned additional AG, who does not oppose the prayer. Hence the prayer is allowed. Let this matter be listed after 3 weeks.
Are you responding?
Lordship, information item 18, it's in the explanation column,
1-8.
180. Lordship. First. Lordship,
Yeah.
I just received a copy of the affidavit of sale. So,
You'll be filing reply.
I get to go through. Lordship.
Okay, okay.
So,
Heard Mr. I.A. Pongner, learned counsel for the petitioner. Also heard Mr. Imtin Song, learned additional AG, appearing for state respondent. Learned counsel for the petitioner submits that he has received the copy of the affidavit in opposition filed by the respondents just today only,
yes. sir.
and
Yes.
therefore he seeks some time for going through the same. Considering the submissions made by learned counsel for the petitioner, let this matter be listed. Tuesday is on 26th,
Like-
26 August.
Lordship, I beg to mention item number 19. Lordship, yeah, I've yet to receive the instruction. So 2 weeks time will be granted, Lordship.
9 and 10.
19,
19. Okay. Heard Mr. Imtin Song, learned additional AG, who seeks for 3 weeks time on the ground that he is yet to receive instructions from the respondents in this matter. Mr. Yangarwati, learned counsel for the petitioner, does not oppose the prayer. Hence, same is allowed. Let this matter be listed after 3 weeks.
I'm prepared for respondent.
Show the presence of Mr. N. Muzoi, appearing for respondent number 4. The registry is directed to reflect the name of Mr. N. Muzoi as engaged counsel as standing counsel for respondent number 4.
Please, Your Lordship. Maybe please to mention item number 23, Your Lordship. Your Lordship, here we have received instruction. So while going through the instruction, we felt that like there was some conflict of interest, Your Lordship, between the department and the government, and therefore it has become necessary for us to seek instruction from the government. So Your Lordship, another 2 weeks may be granted so that the necessary instruction clarification can be sought for.
My lord, this is the 7th time they're asking the adjournment, 7 times. So therefore, last time also in my humble submission, last time also I waited to court that this will be the last adjournment because the internal crisis has nothing to do with me and with the court. Then they should show that is not the excuse. Therefore, I have the responsibility towards my.
Your
client.
name is not shown in the cause list.
Your Lordship, here I'm assisting my additional AG, Ma'am Shukri, Your Lordship.
Because of.
No, the name of none of the counsel for respondents has been shown in the cause list. Heard Mr. A. Zo, learned counsel for the petitioner. Also heard Miss Livika, learned government advocate, who submits that though she has received the instructions in this case, however, some clarifications are still required in view of the apparent conflict of interest which appears in this case between the government and the concerned department. Hence, she seeks
2 weeks, Your Lordship.
2 weeks time.
Because this 7th time, it's the 8th time then. Lordship, there are some difficulties.
You're also making an endeavor, Your Lordship, so that a judicious conclusion can arrive, Your Lordship.
In
And
other,
On the other hand, Mr. Azo, learned counsel for the petitioner, submits that This is for the seventh time the petitioner is seeking. You have not filed affidavit in
Yeah,
opposition.
like we are on the verge of filing,
Okay.
Your Lordship.
This
Then
is
we
for
detect
this
that,
the seventh time the
Okay.
petitioner has sought for adjournment on various pretexts. Considering these submissions made by counsel for both sides, the prayer for grant of time, 2 weeks' time is allowed. However, it is hereby made clear that if the respondents desire to file affidavit in opposition in this case, they shall do so before the next date fix, list accordingly.
Earlier also, 2 times they say they have received the instruction.
This I have reflected in the order sheets. The
Interim is
interim-
also in the favor. Your
But
Lordship.
now that is nothing, it's on bed.
The interim order shall continue till next date. Till next date.
Well,
Your Lordship, I also beg to mention item number 25 on behalf of additional AG Mem Shokri. Your Lordship, if this matter can come up after 2 weeks for filing counter affidavit, Your Lordship.
Lordship, if they have received a instruction, then make it sure that it is filed on the returnable because it involves. I am challenging the entire selection process, which is ongoing presently. And
Okay. Heard Mr. T. Pongner, learned counsel for the petitioner, also heard Ms. Livika submitting on behalf of Ms. V. Sokre, learned additional AG, who seeks 2 weeks' time for filing affidavit in opposition. Considering the submissions, the prayer is allowed. Let this matter be listed after 2 weeks.
the state respondents ensure that the affidavit is filed.
Nothing.
Your Lordship, I beg to mention item number 32 and 33 of the hearing list. Your Lordship, on behalf of additional AG V Sokre, kindly let the matter come up after 3 weeks.
Lordship, in that case, the matter will be fixed on 16th of September.
16 is okay.
Appearing for installment 621. And item number 33, Lordship.
Heard Miss A. Aimi, learned counsel for learned government counsel appearing, submitting on behalf of Miss V. Sokri, learned additional AG, who seeks an adjournment for 3 weeks. Also heard Mr. Supongwati Waling, learned counsel for the petitioner, as well as Miss Apila Sangtam, learned counsel for respondent in writ petition number 221/2022. The adjournment, I have mentioned about adjournments. Considering the submissions, the prayer for adjournment is allowed. Let this matter be listed on
16th of September.
16th is okay, 16th of September.
Your Lordship, item number 34 on behalf of Inaholi, Your Lordship, kindly let the matter come up after 3 weeks.
Who is for the petitioner? Heard Miss A. Aimi submitting on behalf of Miss Inaholi, learned government counsel, who prays for an adjournment. Inaholi is, you are for the pay. Who is
A date may be fixed.
also heard Mr. What is your name?
H.
H. Mukam, learned counsel for the petitioner, as well as Mr. Foseko Forte appearing for the private respondent number 4. Considering these submissions made by learned government counsel, the prayer is allowed. Let this matter be listed. When do you want?
Second week.
In the second week of September, on a date to be fixed by registry.
Much obliged. Mr. Lordship, I'd like to mention hearing item number 30 and 31 on behalf of El Iralo, who is presently in bereavement. I pray that this matter can be listed after 4 weeks.
Heard Miss what is Venoshina, Menoshino, learned counsel for the petitioner. Also heard Miss Lushino, learned.
She's appealing for the private respondent.
Menoshino, appearing for the private respondent. Also heard Miss Lushino, appearing for the writ petitioners. Learned counsel for the petitioner, learned counsel for the private respondent seeks an adjournment on the ground that the conducting senior counsel for the private respondent is in bereavement. Considering the submissions, the prayer is allowed. Let this matter be listed after 4 weeks.
I'd like to mention item number 22, my lord. This is a fixed matter. However, my senior, Mr. Inji Longjam, is also in bereavement today. So if this matter can come up on Thursday, my lord, if my lord permits.
In fact, Your Lordship, the subject matter is quite simple, whether the overdrawn pay for the services utilized.
The counsel is not there.
Yes, my lord. So if
Item number 6.
item number 22, my lord.
22. As my lord is willing, it's a short matter, it can be fixed on Thursday, my lord.
Which Thursday?
Day after tomorrow, my lord.
No,
My lord.
Should
next
be-
Thursday.
Lordship, in that case, I was informed that the state council has difficulties.
After 2 weeks. Because
Lordship,
next week I have.
8th of September, then, my lord, after 2 weeks.
Heard Miss Lushino submitting on behalf of Mr. Imti Longjam,
Yes, my lord.
learned counsel for the petitioner who seeks an adjournment on the ground that the learned counsel for the petitioner is in bereavement. Also heard Miss S. Mary, learned government counsel, as well as Mr. Joshua Sheki, learned counsel for respondent number 5, who do not have any objection regarding the prayer made by learned counsel for the petitioner. Hence, the prayer is allowed. Let this matter be listed
8th of September. Yes.
on
8th
8th,
September, ma'am.
8th
That
of
is it,
September.
after 2 weeks.
Is it 8th of September?
Should I also like to mention, I'm hearing item number 43 and 44. Worship here, my senior, Mr. A. Jimomi, he has some personal difficulties. So if this matter can come up on 8th of September, I know.
May I please, Your Lordship, I have for respondent number 4 here. Lordship, I pray this matter be listed on 22nd of September.
We are not giving fixed date. Let registry finalize the date in the 3rd week. Heard Miss Lucino, learned counsel for the petitioner. Why are you seeking adjournment?
Worship, my senior, he has some personal difficulties today, so Mr. A. Jimomi.
Also heard Mr. What is your name?
V goes up.
V. Koza,
Respondent number 4.
learned counsel for respondent number 4, as well as Miss A. Aimi, appearing for the state respondents. Miss Lushino, learned counsel for the petitioner, has prayed for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner, Mr. A. Zimomi. Stop. To which the counsel for respondent do not have any objection. Hence, the prayer is allowed. Let this matter be listed in the 3rd week of September on a date to be fixed by registry.
Worship, there's an interim here.
The interim order shall continue till next.
Lordship,
Worship, if I may be allowed to make a mention of item number 1 and 2 also, my lord. Worship, here, the pleadings are complete. So if this matter can come up for admission after 3 weeks, my lord. I've taken the consent.
Pleadings are complete.
Yes, my lord. Yes.
Then
that I
we'll
will.
fix it for hearing. We'll admit it. Heard Miss Lucino, learned counsel for the petitioner. Also heard Mr. V. Zimomi, learned government counsel, appearing for state respondent. It is submitted at the bar that the pleadings of this case are complete and this case is ready for hearing. So in view of submission made by learned counsel for both sides, this case is admitted for hearing. Let this matter be listed in the hearing column after 4 weeks on a date to be fixed by registry.
May it please Lordship, my lord, I beg to mention item number 4. My lord, here we are yet to file our affidavit. So I pray that this matter may be listed after 3 weeks, my lord.
What is your name?
B. Soto, my lord.
Heard Mr. B. Soto, learned counsel for
Respondent number 5.
respondent number 5, who seeks
3 weeks. my lord.
3 weeks time for filing
Affidavit.
affidavit in opposition. Also heard Ms. Crowe Skuru, learned counsel for the petitioner, as well as Ms. Bichano, learned government advocate appearing for the state respondents who do not state respondent number 1 to 4. Stop. Considering the submissions made by learned counsel for respondent number 5, the prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry.
Much blessing.
May I please, your Lordship? Lordship, I beg to mention item number 6 to 17, Lordship. Lordship, I'm mentioning on behalf of additional AJLP Santam, Lordship. Lordship, here the state respondent is yet to file affidavit in opposition, Lordship. If Lordship may please to grant under a 3 weeks time.
Your Lordship, in this case, from the month of May this year, you made the submission that the affidavit is under preparation.
Lordship,
It must be very bulky affidavit.
Lordship. And then there is certain clarification we need to solve with the department, Lordship. So
Heard
that is still.
heard Mr. Limao Wang, learned counsel for the petitioner. Also heard Mr. V. Zimomi, learned government counsel submitting on behalf of Mr. L.T. Santam, learned additional AG, who seeks 3 weeks time for filing affidavit in opposition by the respondent sides. The prayer is allowed. Let this matter be listed after 3 weeks.
Hello.
Lordship. Lordship, I'd like to mention item number 20 and 21. Your Lordship, here we are yet to file our affidavit in the blood. If 3 weeks may be granted relations.
Heard Miss, what is your name?
Shisa Jamir.
Heard Miss Sisha Zamir, learned counsel for the petitioner. Also heard Mr. N. Angami, learned senior government counsel appearing for
State respondent.
state respondent, as well as Mr. What is your name? Be louder. Oh, yes, Hising Lohim. Appearing for respondent number
In item number 20, WPC 194, 5 to 8, and 10 to 35. And in item number 21, 5 to 27.
you give it in a slip. Abhishek note ke? Take it from learned counsel for the petitioner seeks some time for filing reply to the affidavit in opposition filed by the
State as well as private
filed
respondents.
by the respondents. The prayer is not opposed to by the counsel for respondent sides. Hence, same is allowed. Let this matter be listed after 3 weeks.
Maybe it's Lordship. Lordship, I beg to mention item number 36, 37, and 38, Lordship. Hearing item. If this matter can be listed after 3 weeks, Lordship.
No objection.
Mm.
36, 37, and 38.
Lordship.
Heard Mr. Supong Watiwaling, learned counsel for the petitioner. Also heard Ms. S. Chang, learned counsel, learned government counsel,
Lordship.
learned government counsel, as well as Ms. Mika H.I. appearing for private respondents. Learned government counsel has prayed for 3 weeks' time for filing affidavit in opposition.
Lordship, we have a. This is hearing matter, Lordship.
Why are you seeking adjournment?
No, I have some difficulties, Lordship.
Sorry. Learned 3 weeks' time on the ground of personal difficulties of the conducting counsel, to which learned counsel for the petitioner has no objection. Hence, same is allowed. Let this matter be listed after 3 weeks.
Lordship, I also beg to mention item 26, Lordship. If 1 week time is granted to me to file my affidavit in opposition, Lordship. 26.
Heard Mr. Joshua Sheki, learned counsel for the petitioner, also.
Here, one clarification is required. On 14th of July, a notice was sent to my client. My lord, there is a small finding which is confusing, which requires some clarification.
Albert. What is this notice?
A notification was issued and my client went to the village. Then, your lordship, the next page, the re-verification. The language is confusing. Here, the department, the government is trying to say that we have not donated the land, but there was a deed of agreement between the respondents and the petitioner, your lordship.
No, now what you want to say?
Now, what I want to say, your lordship, is now, my lord, the language is not clear. It appears to show that we are also one of the donees of the land. And according to the deed of agreement, which was executed in 2000. But at the same time, if you read the language, your lordship, it's a very short paragraph. May I read, my lord?
Yes. What is the matter here?
Your lordship, the petitioner is seeking for appointment on the basis of land ownership.
Okay.
And the department is showing only the gray area. They're not directly saying that we're not the donor. At the same time, they're saying
Okay.
that we're not entitled.
Read what?
Changsa Health and Wellness Center is located well within late Renpamo Odio's clan land. Till the present moment, the only motorable road approaching to the Changsa Health and Wellness Center and available parking space is located within the donated land by deed of agreement registered 67 2000 dated 3/5/2000 of Srimati Chapini P. Kitan, granddaughter of late Nremo Kitan. So, my lord, clarification may be brought by the state because it doesn't say that we are the donee. It does not deny also that we are also one of the donees.
No, they are seeking time for filing affidavit in.
Yes, your lordship. But this clarification also may be brought because this will create problem in the at the time of
No,
the.
if you
arbitration
have
also,
some,
your lordship.
any objection with this notification, you bring your concern on record by filing additional affidavit.
My lord.
You bring it on record. How it affects you and what do you want?
Your lordship. Your lordship.
And this is item number
26.
26. Heard Mr. Joshua Sheki, learned counsel for the petitioner. Also heard Mr. M. Long Kumer,
Yes. And
Learned Government Council, as well as Mr. W.R. Anguli, appearing for respondent number 4. Learned Government Council's praise for how much time you are seeking?
1 week.
1 week time for filing affidavit in opposition. On the other hand, learned
Additional affidavit, Your Lordship, to place on record verification report. Yes, additional affidavit.
praise time for filing an additional affidavit for bringing on record the verification report.
Yes.
This verification report
Yes, verification report by the,
dated 16 July.
There are several verification reports, Your Lordship.
Okay, let them file
yes.
verification report.
Yes, Your Lordship.
On the other hand, Mr. Joshua Sheki, learned counsel for the petitioner, has also sought leave of this court to file an additional affidavit for bringing certain facts on record in light of issuance of notification dated 14 July 2025 by the Chief Medical Officer, Wokha, Nagaland. The prayer is allowed. Let this matter be
I
listed.
note the service notice upon the respondent number 5. My lord, till date, they are yet to appear, the village council. So dusty services, my lord, may kindly allow us to serve dusty service.
It also appears you have gone through the record.
Yes, Your Lordship.
What is the office note?
Yes,
Then
The
we,
village council is yet to appear, my lord.
it also appears that respondent number
5.
5. There is no service report as regards service of notice issued to the respondent number 5. The petitioner, the learned counsel for the petitioner, therefore prays for allowing the petitioner to take steps upon the respondent number 5. Additionally, by way of dusty mode, the same is allowed. Let fresh notice be issued to respondent number 5 within 7 days from the date of this order, as 7 days from the date of this order by registered post with AD, as well as by usual mode, returnable after three weeks. Additionally, the petitioner is also allowed to take steps by way of dusty mode. Stop. After serving the notice by way of dusty mode, the petitioner shall file an affidavit in compliance to that effect before the next date fixed. List accordingly after 3 weeks.
My lord, blush.
Your Lordship, I also like to mention item 27. I pray for 3 weeks, Your Lordship, to file affidavit in opposition. The state respondents.
No objection, Lordship.
What is the name?
Applicant banyak. Appearing on behalf of Sandy Young, Lordship.
Heard Mr. Write his name. Repeat your name.
Yes. Lordship,
You give in a slip
sure. Lordship.
submitting on behalf of Mr. Senti Yange, learned counsel for the petitioner. Also Mr. M. Long Kumar, learned government counsel, who seeks 3 weeks time for filing affidavit in opposition, to which the learned counsel for the petitioner has no objection. Hence, same is allowed. Let this matter be listed after 3 weeks.
Lordship, I'd like to mention item number 28, Lordship. Lordship, here, service upon respondent number 7 is still available, Lordship. So
What is to be
some
done?
weeks may be granted. So that we will await. If they don't respond, we will take up the fresh step, Lordship.
Heard Mr.
Noklay M. Punyak,
Long,
Noklay M. Punyak,
write his name, learned counsel for the petitioner. Also heard Mr. M. Long Kumar, learned government counsel appearing for the state respondent. It appears from record that service report in respect of
Respondent number 7.
in respect of notices issued to respondent number 7 has not yet returned. Stop, await further. Let this matter be listed after 2 weeks.
Lordship. There is interim, Lordship.
The interim order shall continue till next week.
Okay.
May I please, Your Lordship? Your Lordship, I beg to mention hearing item number 35. Your Lordship, here I have received instruction from my client to withdraw the case of the present writ petition, Your Lordship. Therefore, I pray that Your Lordship may allow me to withdraw the present writ petition.
What is your name?
Yes, Chilian.
H. Zeliang.
Yes, Your Lordship. Lordship, I have taken consent from the opposite party.
Heard Miss H. Zeliang, learned counsel for the petitioner. Also heard Miss S. Chang, learned government advocate. Learned counsel for the petitioner submits that she has instructions from the petitioner to pray for withdrawal of the instant writ petition. The prayer is not opposed to by the council, learned government council. So considering the submissions made by learned counsel for the petitioner, the prayer is allowed. This writ petition is dismissed on withdrawal.
Yes, Your Honor.
From the supplementary cost list for motion, item number 48.
Next, Lordship, yesterday. Downward court has some query regarding whether the impugn order passed by the.
Whether you are a state, you
Or-
comes within the definition of.
I may. Statistics of the court, Lordship, I may be allowed to place one to judgments in the Supreme Court. Lordship, 1989 to SCC 691.
Yes,
Paragraph 18. From paragraph 18. 1989 to SCC 691. From paragraph 18, Lordship. The Lordship got it all, and I may be allowed to read out, Lordship.
yes, please read.
Paragraph 18. Article 2 to 6 reads. Power of the High Courts to issue certain writs. Notwithstanding anything in Article 32, every High Court shall have the power to territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases, any government within those territories, directions, orders, or writs, including writ in the nature of habeas corpus, mandamus, prohibition, covenanto, and certiorari, or any of them for the enforcement of any of the rights conferred by Part 3 and for any other purpose. Lordship may come to paragraph 20 also. Paragraph 20.
Yes.
The term authority used in Article 226 in the context must receive a liberal meaning, unlike the term in Article 12. Article 12 is relevant only for the purpose of enforcement of fundamental rights under Article 32. Article 2 to 6 confirms power of the High Courts to issue writs for enforcement of the fundamental rights as well as non-fundamental rights. The words any person or authority used in Article 226 are therefore not to be confined only to statutory authorities and instrumentalities of the state. They may cover any other person or body performing public duty. The form of the body concerned is not very much relevant. What is relevant is the nature of the duty imposed on the body. The duty must be judged in the light of positive obligation owned by the person or authority to the affected party. No matter by what means the duty is imposed, if a positive obligation exists, mandamus cannot be denied. Lordship, I may be also.
Now, how it helps you?
Lordship, here is so. So this is the authority that has passed the in order. So here
Thereby,
Honorable Court, under
it
226,
violated your which rights? Albert,
my rights under Article 19, Lordship, 14 and 19, Lordship,
constitutional.
and 21,
Fundamental right.
Lordship. Lordship, I mean, we also have to rely on the Lordship, 2015, the ACC 215. Control for cricket.
14 and 19.
Lordship.
That means your fundamental rights are violated.
Fundamental right, right.
But you are showing a judgment that relates to issuance of writs in the nature of what has been mentioned in Article 226
The writ-
for enforcement of non-fundamental rights also.
fundamental as well as non-fundamental, Lordship.
So if it is
Lordship, I may be allowed to rely on another citation, Lordship. The apex court.
under Article 14, the obligation is on state. State shall not deny to any person. So it is.
I have a letter representation to the state also.
No, but you are seeking relief not
From,
against
yes, Lordship, not from the state.
state. So
From the president.
therefore, I have put the query that whether this writ petition is maintainable or not. You have to satisfy me that the respondent against whom you are seeking relief
I am allowed to rely on another judgment, Lordship. 2015 ACC 215, Lordship.
Yes.
Relevant para is para 32, 33, 34, and 35, Lordship. Para 32, 33, 34, 35.
Yes.
Lordship, am I allowed to read?
Yes.
Having said that, this court recognized the fact that the board was discharging some.
Where are you reading? Para 32.
32. 115 3 ACC, Lordship 251.
This is
2000.
wrong citation.
The Lordship, in 2005, that's 2005, Lordship, I may be allowed to
Yes.
rely on that 2005. Paragraph is 31, Lordship. 31 in 2005. Paragraph is 31.
Yes.
Be that as it may, it cannot be denied that the board does discharge some duties. My apologies. Be that as it may, it cannot be denied that the board does discharge some duties like the selection of an no lord.
Now, what is
No,
the,
Lord.
Mr. Forte, what is the line of your submission that?
That
you wa-
lordship,
No, you want to say that the respondent is a state or
not a,
no?
even though it's not a state lordship, it's a body, apex body of the tribe of the petitioner, and the body that authority has passed an imperial order.
It is
Excommunicating
not a state within the meaning of 12.
to lordship. No, as per what I'm relying on my judgment, it does not say so, but since his fundamental rights has been violated, lordship, I read lies under 226 lordship. That's my submission, lordship. Lordship I may be allowed to rely on 2019 volume 1 lordship. Yeah, all those judgments have been relied lordship. 2019 volume 1 GLT. Lordship, here also the petitioner has been excommunicated from the village by the village council, and the village council, as per it covers under Article 12. But lordship, here the discussion has been made.
But it is not a village council.
No, lordship, it's not a village council, but lordship,
You are a private body.
I'm a private body, lordship. So lordship, I may be allowed to rely on this lordship.
Yes.
Then, 11 portion is at page para 22, lordship. Para 22. Para 22.
Yes.
Lordship got it. I may be allowed to.
Yes.
From the above, what transpires is that even if the respondent numbers 4 and 5 are considered not to be village council or part of it, as envisaged under Section 3 of the Nagaland Village and Area Council Act 1978, as contended by respondent 4 and 5, this nevertheless exercise extensive control over the social lives of the villagers to the extent that the Yongsangar Putu Chatar Salam can penalize a person or a group of persons if their acts are impermissible under the customs and traditions of Interim village by banishment from the village jurisdiction for a specific period and even permanently. Various other forms of punishments are prescribed as mentioned above, which includes locking of the wrongdoer's house, killing of pig, and distributing its meat to the villagers. These customary practices are also codified in Yemten Temzeng. Thus, these bodies, even if they are not creatures of statutes under the Nagaland Village and Area Council Act 1978 or any other statutes, as clarified by the respondent 4 and 5, are endowed with the authority not only to regulate the social lives of the villagers according to the customary laws, but also to penalize the villagers to enforce the customary laws, which power and authority are not endowed to any other body in the village/society. Thus, apart from the regulatory power relating to customary practices and laws, it has a monopolistic power over the villagers in this aspect. From the pleadings of the respondent 4 and 5, it is clear that this otherwise private entities has pervasive control over the social life of the villagers with punitive and monopolistic regulatory power of the villagers. These bodies, even if not government bodies, discharge duties which are public in nature. It is not confined to only a few individuals, but their wreaths run over the entire village, who are subject to their decisions, who may disobey on the pain of punishment and penalties. The wreath of the respondent 4 and 5 runs within the entire society and thus is within the domain of public law, especially when it involves punishment like banishment and excommunication. In such a situation, this court is of the view that the principle of law laid down in Board of Control of Cricket in India versus Cricket Association of Bihar passed in 2015 3 SEC 2541 would be attracted, thus opening the door of the High Court under Article 226 of the Constitution to those who may be aggrieved by any decision of such bodies, even if it is deemed that these bodies are not state or any authority within the meaning of Article 12 of the Constitution. In the said case, it was held as follows. Having said that, this court recognized the fact that the board was discharging some duties like the selection of Indian cricket team, controlling the activities of the players, which activities were akin to public duties or state functions, so that if there is any breach of the constitutional or statutory obligations of the rights of the other citizens, the aggrieved party shall be entitled to seek redress under the ordinary law or by way of a writ petition under Article 226 of the Constitution, which is much wider than Article 32. This court observed Z Telefilms Limited case in zone 54 SEC 649 SEC page 68 paragraph 31. Be that it as it may, it cannot be denied that the board does discharge some duties like the selection of an Indian cricket team, controlling the activities of the players and others involved in the game of cricket. These activities can be said to be akin to public duties or state functions, and if there is any violation of any constitutional or statutory obligations or rights of the other citizens, the aggrieved party may not have a relief by way of a petition under Article 32, but that does not mean that the violator of such right would go scot-free merely because it or he is not a state. Under the Indian jurisprudence, there is always a just remedy for the violation of right of a citizen. Though the remedy under Article 32 is not available, an aggrieved party can always seek remedy under the ordinary course of law or by way of a writ petition under Article 226 of the Constitution, which is much wider than Article 32. The majority view thus favors the view that BCCI is amenable to the writ jurisdiction of the High Court under 226, even when it is not stayed within the meaning of Article 12. The rationale underlining that view if we may say with utmost respect lies in the nature of duties and functions which BCCI performs. It is common ground that the respondent board has a complete sway over the game of cricket in this country. It regulates and controls the game to the exclusion of all others. It formulates rules, regulations, norms, and standards covering all aspects of the game. It enjoys the power of choosing the members of the national team and the umpires. It exercises the power of disqualifying players, which may at times put an end to the sporting career of a person. It spent crores of rupees on building and maintaining infrastructures like stadia, running of cricket academics, and supporting the state association. It frames pension schemes and increases expenditure on coaches, trainers, etc. It sells broadcast and telecast rights and collects admission fee to venues where the matches are played. All these activities are undertaken with the tacit concurrence of the state government and the government of India, who are not only fully aware but supportive of the activities of the board. The state has not chosen to bring any law or taken any other steps that would either deprive or dilute the board's monopoly in the field of cricket. On the contrary, the government of India has allowed the board to select the national team, which then recognized by all concerned and applauded by the entire nation, including at times by the highest of the dignitaries when they win tournaments and bring laurels home. Those distinguishing themselves in the international arena also are conferred highest civilian awards like Bharat Ratna, Padma Vibhushan, Padma Vishun, and Padma Shri, apart from sporting awards instituted by the government. Such is the passion for this game in this country that cricketers are seen as icons by youngsters, middle-aged, and the old alike. Any organization or entity that has such pervasive control over the game and its affairs and such powers can make dreams end up in smoke or come true cannot be said to be undertaking any private activity. The functions of the board are clearly public functions which till such time the state intervenes to take over the same remain in the nature of public functions. No matter discharged by society registered under the Registration of Society Act. Suffice it to say that if the government not only allows an autonomous / private body to discharge functions which it would in law take over a regulate, but even lends its assistance to such a non-government body to undertake such functions which by their very nature are public functions, it cannot be said that the functions are not public functions or that the entity discharging the same is not answerable on the standards generally applicable to judicial review of state actions. Our query to question 1, therefore, is in a negative. For the first part, an affirmation, for the second, BCCI may not be state under Article 12 of the Constitution, but is certainly amendable to writ jurisdiction under Article 26 of the Constitution of India.
Now, what is your submission?
Lordship, in such a case where the petitioner's rights and is violated by passing the impugned judgment by the impugned order is at the page 59, Lordship, by the United Sanctam Lincum. Lordship, this honorable court has the jurisdiction to pass a necessary orders, Lordship.
Who is for the other side?
And
Mr. Imchen is appearing.
at this stage, Lordship may be gracious enough to stay the impugned order, Lordship. It's my humble prayer, Lordship.
You don't want any interim now.
Lordship, I need interim, Lordship. Can you may stay this?
Who are the respondents?
Lordship, the respondents are 1, and 2 are the state. 3, 4, 5, and 6 are the body is a 3. The United Sanctum becomes implemented by the president. 4, 5, and 6 are the vice presidents and executive conveners.
Who is appearing for the state? Okay. Heard, Mr. Fonseca Forte. Okay. What is United Sanctum Lincum Pumji? What this body, how this is constituted?
Lordship, this is the tribal body of the Sanctum, the apex tribal body, Lordship, and the petitioner belongs to the apex, to Sanctum tribe, Lordship. So, as per the Constitution, Lordship, they govern over all the Sanctum people.
My lord, your lordship, before you make an order, the petitioner is not challenging the action of the state because he was excommunicated by an authority, United Sanctum Lincum Pumji. That means this tribe usually live in Gauhati district. So the petitioner was excommunicated by that authority, tribal Hoho, by that only. And this United Sanctum Lincum Pumji is not this registered society also, it is a civil society organization. When it was excommunicated by the order, your lordship, 59 annexure 3, that is 15 July 2024. State were given only a copy. We were given only a copy for information only. So state cannot be a party here.
What relief you are seeking against state? Why have you made them party?
This is purely a civil nature, Your Lordship. I don't know.
Since the organization is established under the in the state of Nagaland and under the KP district lordship, we have communicated this order. The imperial order has been communicated to the
No,
to
but
the
this is a private body.
lordship. So lordship, we have the petitioners also written a letter to the DC to act upon, and the DC EAC it has also forwarded a letter to the president lordship. So in such cases, lordship, the state is a necessary party lordship. Even though we're not seeking any relief from the state lordship,
Your Lordship is
the law and order lordship and administration is with the state lordship.
Your Lordship is very well aware that this extraordinary jurisdiction under 226 of the Constitution is a certain enforceable legal right must be violated. Apart from the violation of Part 3 of the Constitution here, nothing has been made of. Where's the violation of the enforceable legal right by the state?
Where in your petition you have stated what the petitioner, about the petitioner's functions and role and functions? Only in para 1.
In respect to the article lordship,
About this United Sanctum Licum Pumji. How this court will assess whether it falls within the ambit of judgments which you have cited. Even if it does not, if it is not, you have cited a judgment which says that even if it is not a state, it impact on these societies, if it is all pervasive and it,
yes.
like, where are those statements?
Lordship,
Para 8.
there are 8 and 9 lordship. There are 8, 9 and the lordship that the let me go to read lordship.
No, that is not sufficient. Even if the judgments which you have cited is to be made applicable.
Your Lordship, the judgment which has been read out by my friend is not applicable in the present case. Because the Lordship, in this
No, let me put queries. The judgment of this, the coordinate bench of this court which you have cited was in regard to customary tribal bodies
Lordship.
which have pervasive control over the social life of the villages with punitive and monopolistic regulatory power over the villages. Where are these statement in your writ petition that you also falls? This is the nature of the The
Lordship, para 14, 11, Lordship. That's at page 13. Lordship, Lordship, then. To strictly, you will not read Lordship.
yes,
To strictly adhere to the traditional customary laws, to rule over all the citizens of the sanctums. C. In the occurrence of land dispute in border areas, it shall deliver judgment with fair and justice. In the event of land dispute between villages and conflicting issues among civil societies, it shall deliver judgments after thorough investigation. In order to advance in the pursuit of higher education, to promote sound financial management, to nurture efficient political leaders, deliver judgment with fairness as and when conflicting issues arise in neighboring state. And Para 12, that the humble petitioner most specifically states that Article 16 of the Constitution of the USLP reflects whenever any issue is brought before the USP, a court fee of so and so shall be charged, which shall be followed by a cross-examination and delivery of its judgment. All the cases that cannot be handled by the arranged this area USLPs shall take up to deliver fair trial and judgment. As and when necessary, USLP may select its members to represent the organization. USP shall be the highest decision-making body above all societies, unions, village under its jurisdiction. Be respectfully stated that examining part of the admitted that USLP is having authority to adjudicate any disputes being brought before it. When Article 16 of the Constitution of the USP provides that whenever any issue is brought before USLP, a court fee of finance shall be charged, which shall be followed by cross-examination in the area of judgments. That Part 13, that the humble petitioner must respectfully state that the petitioner on 25/17/24 received the impediment exclamation.
okay. Heard Mr. Foseko Fote, learned counsel for the petitioner. Also heard Mr. Moa Zamir, Moa Imchen, learned counsel for learned senior government counsel, appearing for respondent number 1 and 2. This writ petition under Article 226 of the Constitution of India has been filed by the petitioner, namely Shri Likum Se Sanctum, who is aggrieved by excommunication notice bearing number USLP/KPE/excommunication/2023/03 dated 25/7/2024, issued by the United Sanctum Likum Pumji, with having its headquarters at Kipire, Nagaland, within bracket, represented within bracket, respondent number 3 in this writ petition. Learned counsel for the petitioner has submitted that the petitioner hails from Sanctum Naga tribe and Sanctum Naga tribes. And the respondent number 3 is the respondent number 3, that is United Sanctum Likumpumji, is the apex body of Sanctum Naga tribe. The petitioner, learned counsel for the petitioner, submits that the petitioner on 8/7/2024 had expressed his views in his personal capacity, in a WhatsApp group, namely Voice of ENPO within inverted comma, Voice of ENPO within inverted comma, regarding the process of nomination of the members of the process of ENPO nominating committee. Stop. Learned counsel for the petitioner has submitted that, annoyed with the act of the petitioner, the respondent number 3 issued the excommunication notice referred herein above, dated 25/7/2024, whereby the petitioner was arbitrarily and illegally excommunicated from the Sanctum community for a period of 15 years. He was also debarred from representing the Sanctum community in any government/non-government department/organization, as well as he was debarred from getting any recommendation/NOC from the village/area/tribe. It is also submitted by learned counsel for the petitioner that the petitioner was also debarred from filing any case in any court of law against any member of Sanctum community. He, learned counsel for the petitioner, submits that though the petitioner number 3 is not a state or does not come within the purview of state as defined in
Under Article 12.
Article 12 of the Constitution of India. However, as the apex body of the Sanctum community, the respondent number 3 has all pervasive control over the social life of the villagers of Sanctum community. Stop. He also submits that the respondent number 3 discharges duties which are akin to public duties, as it also penalizes it can also impose penalty to the members of Sanctum community under certain circumstances. He also submits that the respondent number 3 is the highest decision-making body of the Sanctum community, and therefore, even though it does not comes within the purview of definition of state within inverted comma, under Article 2012 of the Constitution of India. However, an application under Article 226 of the Constitution of India is maintainable. He also submits, in support of his submission, he has cited a ruling of the apex court in the case of Andi Mukta Sadguru Shri Muktaji Vandas Swami Suvarna Jayanti Mahotsav Smarak Trust and others versus B.R. Rudani and others, reported in 1989 2 SCC 691, wherein it was observed by the apex court that Article 226 confers powers on the High Court to issue writs for enforcement of, or not only for enforcement of fundamental rights, but also for enforcement of non-fundamental rights. Stop. He also has cited a ruling of a coordinate bench of this court in the case of Mayang Lima versus State of Nagaland and others, reported in 2019 1 GLT 409. To impress upon his submission, in support of his submission, that the respondent number 3 may not be stayed under Article 12 of the Constitution of India, but is certainly amenable to writ jurisdiction under Article 226 of the Constitution of India. On the other hand, Mr. Moim Chen, learned senior government advocate, appearing for respondent number 1 and 2, has submitted that in this case, no relief has been sought for by the petitioner against the state respondents, and the respondent number 1 and 2 are not necessary parties to this writ petition. He also submits that the relief sought for by the petitioner is against private entities, and therefore the same is not amenable to writ jurisdiction under Article 226 of the Constitution of India. I have considered the submissions made by learned counsel for both sides. Considering the submissions made by learned counsel for the petitioner. This court is inclined to issue notice at this stage, keeping the question of maintainability of this instant writ petition open. No interim at this stage. Let the
Because
respondent appear.
his rights has been violated, Lordship. I mean.
No, you
Lordship,
take,
in-
let the respondent appears. The petitioner shall take steps for issue as Mr. Moim Chen has appeared for respondent number 1 and 2. No formal notice is required to be issued against the said respondents. Stop. However, learned counsel for the petitioner is directed to furnish requisite number of copies of the writ petition along with annexures to the learned senior government counsel for respondent number 1 and 2. As regards respondent number 3, 4, 5 and 6 are concerned, the petitioner shall take steps for issuance of notice on the said respondents after said respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. The prayer for interim relief shall be considered only after due service of notice on the private respondents. List accordingly.
It's much more.
For motion, item numbers 49 and 50.
Mr. Lordship, here the present application has been filed for deletion of 33 numbers of petitioners, Lordships. In my application, it page 12, paragraph 2, Lordship. Here, Lordship, well pending of the WPC 170 of 2024 before this honorable court. Now 30 number of petitioners if service has been regularized as per the
How many petitioners were there originally?
41 petitioners, Lordship, in WPC 170.
How many have been regularized?
30 petitioners have been regularized, and then other 3 petitioners, that is petition number 10, 13, and 22. They have not reached the service limit of 30 years, that is as per the OM. So as of now, they are premature. So I filed this application for deletion of those petitioners in the main petition.
10, 13.
And 22. They have not reached the 30 years of service.
Yes, Ms. Chang, you have any objection? Heard Mr. Supungwati Waling, learned counsel for the applicant. Also heard Ms. S. Chang, learned government counsel appearing for the respondents, state respondents. This application, this interlocutory application has been filed by the applicants in connection with writ petition number 170/2024, which was filed by the applicants praying for regularization of their services. Stop. Learned counsel for the petitioner has submitted that during the pendency of the aforesaid writ petition, the services of petitioner number 3, comma,
1 from 1.
oh, yes,
Perfect.
1, 3. Where is the statement in the
Page 12 of my paragraph 3. Page 12, para 3.
Petitioner number 1, 3, 5, 7, 8, 9, 12, 15, 16, 17. See the number from para 3 at page 12. Other numbers have already been regularized. And therefore, this writ petition has become infructuous in as much as the said petitioners are concerned. Learned counsel for the petitioner has therefore submitted that their name may be deleted from the memo of parties in the connected writ petition. Learned counsel for the petitioner has also submitted that the petitioner number 10, 13 and 22 do not intend to proceed with the connected writ petition as they have not yet attained the minimum eligibility criteria of 30 years for getting regularization in terms of Government OM dated 17/3/2025.
2015 motion.
2015, sorry, 2015. Stop. In learned counsel for the applicant therefore submits that the name of the aforesaid petitioners may be allowed to be deleted from the connected writ petition. And he may be allowed to amend the writ petition accordingly. Writ petition number 170 /2024 accordingly. Ms. S. Chang, learned government counsel, considering the submissions made by learned counsel for the petitioner, does not oppose to the prayer made by the petitioner. The prayer made by learned counsel for the petitioner. Stop. Considering the submissions made by the learned counsel for the petitioners as the instant writ petition has become infructuous insofar as the applicants of this interlocutory application except petitioner number 3, petitioner number 10, 13 and 22 are concerned. Hence, the prayer for deletion of their name is allowed. As regards as petitioner number 10, 13 and 22 are concerned, as they do not intend to pursue this matter any further, their names are also allowed to be deleted. The petitioner shall file an amended writ petition in the connected WPC number 170/2024 accordingly. This interlocutory application is accordingly disposed of. List this matter, how much time will you?
2 weeks.
List this matter after 2 weeks.
Publish.
For motion, item number 51.
Yes.
This is a case from School Education Department.
School
School
education.
Education Department is a vast department having so many branches and so many category of employees. The present petitioner belongs to the primary teachers. Among the primary teachers, there are three categories. One, the lowest, the direct recruitment is in the primary teacher. And next promotion is senior primary teacher, grade 2. And the next is senior primary teacher, grade 1, which is pay level 8. As per the ROP, pay level has been fixed. Pay level 8 is the senior primary teacher, grade 1. Pay level 7 is senior primary teacher, grade 2. Pay level 6 is primary teacher.
Okay.
So, as per the provisions of the Nagaland School Education Service Rules 2017, in order to promote to the post of senior primary teacher, grade 2, a minimum length of 7 years is required, besides the educational qualifications. And for the next promotion, that is to the post of senior primary teacher, grade 1, it requires 14 years, 7 plus 7. So
Okay.
the petitioner is eligible to be considered for promotion to the post of senior primary teacher, grade 1, where the pay level is 8.
8.
Although he was not promoted to the post of primary teacher, senior primary teacher, grade 2, MACP, because Lordship is well aware, if in a certain period of after attaining the eligibility criteria for promotion, the promotion is not effected, then as an incentive, MACP is granted. So the petitioner has been granted MACP, that is in the pay level 7. That is
Assured Career Progression Scheme.
exactly the
What M stand for? M is in MACP. Modified.
modified
Okay.
assured
Career Progression Scheme. Okay.
So it is a new nomenclature. Now the petitioner is due for promotion to the post of senior primary teacher, grade 1. That is at pay level 8.
That is your contention.
Yes, he is deprived of that.
Okay.
So at this stage, Lordship, road is very clear. And the government has also said that, yes, they are entitled because we have submitted representation. Of course, it was in the name of a group. Now, the department, that is the directorate, the principal director has arbitrarily and whimsically fixed a date, that is 31st December 2009.
What date?
That is a date where they have collected the list of teachers with effect from that date, and only those persons who are appointed on or before that, only they will be entitled to get the promotion. But service role doesn't say that, and the government letter also doesn't mention anything about 31/12/2009. An arbitrary date has been chosen by the principal director so as to deny the promotions, because they have fixed that as an eligibility criteria, that is 31/12/2009. Service role doesn't say this. Even the government letter also doesn't see that. Kindly, Lordship, we come to page 39.
What is this 31/5/2024?
31/5/2024 is a letter. Lordship will find it page 29. This is the letter of the principal director. I believe it's on page 29. Yes. 31/5/2024.
We issue notice.
Lordship. But we are apprehending that the department may implement basing on the immune orders. So no consequential action should be taken so as to adversely affect the rights of the petitioner.
No, that blanket. Why are you apprehending that they will appoint someone?
Because in view of the orders which has been
You have
issued,
filed any representation or no?
in terms of the
That
representation was by,
you are claiming that by virtue of the tenure of service,
yes, Lordship,
you are entitled to
yes,
be considered for promotion
yes,
to grade 1 primary teachers, senior grade
primary
1,
teacher grade 1.
grade 1. Now you have, why are you apprehending that you are excluded? Because of that cutoff date.
Yes, Lordship. Check.
Cutoff date is by which?
31.
Which is that letter?
Later, Lordship will find at page. There are 4 immune orders. In all the orders, Lordship will find, but latest one will be 20 May 2025. That is at page 44. On or before 31st December 2009. That is based on a meeting minutes, which is at page 43. This is the type copy. The pre-page to page 44 is page 43, 20th May 2025. This is a minutes which was taken on 15th of May 2025.
Which one? Page?
Page 43, Lordship. This is the type copy. This is the minutes of the meeting to study the tentative seniority list of primary teachers held on 15/5/2025 in the office chamber of the additional director, Directorate of School Education at 10:30 a.m. And then we are concerned with the second middle of the page in the second para. After deliberations, the followings were decided. And then Lordship will find serial number 1 and 2. The seniority list will be recalled till 2009 in the first phase, in line with the graduate teacher seniority list. Number 2, collect service books with all necessary service records, documents, initial appointment order, regularization order, highest academic qualification,
When were you
professional
appointed?
qualification of
When
all the
were you
primary
appointed?
teachers.
When were you appointed?
I am appointed in 2001. And
2001?
Regularized in 2012.
Then if your initial appointment is in 2001,
Yes.
then you come within the purview of.
No, Lordship. 2001, but regularization was done only in 2012 with effect from 2011. So when it comes to 2009, then I'm excluded.
Okay. Okay, heard, Mr. This is item number
51.
Mr. C.T. Zamir, learned senior counsel assisted by Miss Krovi Sakru, learned counsel for the petitioners. Also heard Mr. V. Zimomi, learned government advocate appearing for the state respondents. This writ petition under Article 226 of the Constitution of India has been filed by the petitioner, namely T. Izanthung Lotha, who is presently serving as primary teacher at at Government Primary School, Jiangsu. Stop. Learned counsel for the petitioner has submitted that petitioner, as per the relevant government rules, that is Nagaland School Education Service Rules 2017, is entitled for being considered for the promotion as senior government teacher grade 1, as he has already completed 14 years of services, which is the required eligibility criteria for being considered for promotion to the said post. However, the respondent, he is aggrieved with the order dated 20 May 2025, issued by the respondent number, Principal Director, issued by the respondent number 3. Three.
Yes.
Issued by the respondent number 3, whereby the cutoff date of 31st December 2009 was mentioned for consideration of promotion to the post of senior primary teacher grade 1. Which, according to learned counsel, senior counsel for the petitioner, is arbitrary and whimsical, as well as in violation of the relevant rules. Stop. He also submits that same is also in violation of the fundamental rights guaranteed to the petitioner under Article 14 and 16 of the Constitution of India. Issue notice to the respondents. Since Mr. V. Zumumi has appeared for all the respondents, no formal notice need to be issued to the respondents. However, requisite numbers of copies of writ petition along with annexure shall be furnished to the learned government council by the petitioner during the within 2 days from the date of this order. Learned Government Council also sought some time for taking necessary instructions in this regard. The time is granted. Let this matter be listed after how? When?
After 3 weeks.
After 3 weeks.
Pendency of writ petition shall not be a bar for the respondents to consider a case of.
Yes. After 3 weeks. The pendency of this instant writ petition, pendency of the instant writ petition shall not be bar on the respondents to consider the case of the petitioner for his promotion as primary school, primary teacher, senior grade, primary teacher,
Senior
primary teacher,
grade 1.
grade 1.
So many categories are in.
List accordingly.
For motion, item number 52.
May I please, Lordship? Lordship, the instant matter relates with pending bill. Here, the state respondent, respondent number 4.
Pending bill,
Yes, Lordship.
file money suit.
Lordship, since I have
Yeah.
filed the instant application under for violation of Article 14 and 21, since it's my fundamental right. So this instant petition has been moved under Article 26 of the Constitution.
When
Your
it
Lordship,
was due?
actually, I have completed the work and I have also this completion certificate in the year 2007. But the concerned department, they have issued completion certificate in the year 2009, stating that I have completed the work.
So
But-
the money was due to you in the year 2009.
Yes, Lordship. And after the completion, since I had other works also, so in the meantime, I was pursuing this pending bill, but they kept me saying that they will see, they will look into the matter. But ultimately, when so much time was elapsed, so having left with no option, again, I approached the concerned department and also issued notice. But till now, there is no reply from the state respondents.
When you issued notice?
12/9/2024 Lordship. That is page number 15 and 16.
If money was due to you, then you should have gone to civil court. And if you have not gone to the civil court within the limited period of limitation, then they may take plea that it is barred by limitation and there is delay and latches. Even if, yes, Mr. Angami, what is to be done?
Lordship, in fact, there is also a disputed. There is also a dispute between the amount. If my lord can kindly come to page 13. This is a letter written by the sub-divisional PWD Housing Mon.
You are appearing for all the,
All the respondent, your lordship.
what is your submission?
Lordship, actually, yes, when there is a dispute in the amount itself.
No, no. Whether notice may be issued or
Your lordship, that is what I was wanting to say. If there is a dispute in the amount itself, it should be the civil court who should decide, your lordship.
it appears,
Yes, your lordship. It appears that there is a
But-
dispute in the amount,
but we'll decide it later on.
lordship.
We are issuing notice.
Okay,
Heard Mr. P. Surin,
Lordship.
learned counsel for the petitioner. Also heard Mr. N. Angami, senior government counsel appearing for all the respondents. The petitioner, on being aggrieved due to non-payment of his due contractual bill amounting to rupees 3,81,000, has approached this court praying for invoking its writ jurisdiction under Article 226 of the Constitution of India. Though prima facie it appears that there is a delay on the part of the petitioner in approaching this court. However, at this stage, after considering the submissions made by learned counsel for both sides, this court is inclined to issue notice. Stop. Accordingly, let the notices be issued. Stop. As Mr. N. Angami, learned senior government advocate, has appeared for all the respondents, no formal notice need to be sent. The petitioner is, however, directed to furnish requisite numbers of copies of writ petitions along with the annexures to the learned senior government counsel for the respondents within 2 days from the date of this order. Let this matter be listed after 4 weeks.
obliged.
For motion, item number 53.
Yes.
May I place your motion? This petition pertains to the effective functioning of this honorable court, the registry of this court. Since 2000, the honorable Chief Justice was pleased to grant 100, was pleased to approve 180 posts by 13 different orders from 2000. Lord Chief is well aware, under Article 229 of the Constitution, Chief Justice has the power to do that. So he has already discharged his constitutional duties. And the registry of this honorable court has been taking steps from time to time, seeking for implementation of the approval accorded by the honorable Chief Justice so as to create posts. Since 2000, only 20 posts have been created till date. And there is acute shortage of employees, which adversely affect the smooth functioning of this court system. At the same time, the employees are made to work extra time also. And Lordship is well aware, this registry is the only registry in the entire country which is running without a court officer. Court master, sorry. That is pending for so many years, but no steps have been taken by the state. The registry has written several letters to the government for creation of the post. I'm aware that this honorable court cannot issue a direction to the state government for creation of the post. But then in view of the constitutional implications, where under Article 229, the Honorable Chief Justice has already discharged his functions, approving for creation of various posts in various categories. And at present, there is acute shortage of the employees in this registry. So this petition is seeking a direction to the state respondents to take necessary steps. And in the interim, I have also read that the registry may be directed to file a detailed report of the stabbing pattern at present, so that on the basis of such report, this honorable court can pass appropriate orders. The Employees Association has also submitted representation to the Honorable Chief Justice. There we have made a mention that whether either the Lordship should take up Somutu, or in the event of failing to do that, the employee should be allowed to approach this honorable court. To that extent, we have written to the Chief Justice of this High Court also.
Whether there is any bar in roster that matter pertaining to High Court shall be taken up only at principal seat. Is there any bar?
No, there is no bar. If the Honorable Chief Justice is made as a party respondent, then yes, that can be done. That can be taken up only in the principal seat. But since he has
You have made Registrar General as party.
Yes,
Registrar General or Registrar of this?
Registrar of this speech,
Okay.
not the Registrar General. That is
Let-
also to a limited extent that so as to furnish the particulars, so as to file an affidavit explaining the stabbing pattern, stab possession.
You have mentioned that in your writ petition, that what you expect from registrar.
No, we have not categorical mention.
Then,
Only the
then
writ
let him appear. Heard Mr. C.T. Zamir, learned senior advocate, assisted by Mr. I. Im Chen, learned counsel for the petitioner. Also Ms. S. Chang, learned government counsel, appearing for respondent number 124. Stop this
court has a standing consent also.
here.
Chief, I have not been served a copy yet. But
You are
I
the
can
standing
accept
counsel.
notice. My senior Mr. A. Jumomi is the standing counsel of Gauhati High Court.
Okay.
I can accept notice on behalf of respondent number 5.
Also heard Miss Lucino, who appears on behalf of Mr. A. Zimomi, Learned Standing Counsel, Gauhati High Court. This writ petition under Article 226 of the Constitution of India has been filed by the petitioners, has been filed by seven numbers of petitioners, who are employed in various capacities, in the registry of the permanent bench of Kohima permanent bench of Gauhati High Court. The grievance of the petitioner in this case is mainly that due to constraint of, due to that the presently the registry of Kohima, permanent bench of Kohima, permanent bench of Gauhati High Court at Kohima is facing acute shortage of manpower staff. Learned senior counsel for the petitioner has submitted that since the year 2000, on various occasions, Honorable the Chief Justice of this court has accorded approval for creation of
100.
about 180 posts for the registry of the permanent bench of Gauhati High Court at Kohima. However, the state respondents have paid no heed to the same, and only 20 posts
Till date,
were created
since 2000.
since 2000, which is acutely short of what is required for proper and smooth functioning of the registry at the permanent bench of Gauhati High Court, at registry of permanent bench of Gauhati High Court at Kohima. So, learned senior counsel for the petitioners has also submitted that perhaps, the permanent bench of Gauhati High Court at Kohima may be the only bench of the High Court in entire country which is functioning without a permanent post of court master. Stop.
Last paragraph in the synopsis will be relevant. Leaving about 4 lines.
He submits, learned senior counsel for the petitioner submits that due to shortage in the number of employees in various categories of posts, the present employees of the registry of the permanent bench of Gauhati High Court at Kohima are working under constraint for effective functioning of the court. Stop. He submits that delay in creation of the post which were approved by Honorable the Chief Justice, comma, on the part of respondent authorities is arbitrary, exploitative, and violative of the fundamental rights of the petitioners and other employees who are presently working in the permanent bench of the Gauhati High Court at Kohima. Stop. He therefore submits that necessary direction may be issued to the state respondent in this writ petition. Stop. Issue notice. Since Ms. S. Chang, Learned Government Council, appears for respondent number 1 to 4, no formal notice need to be issued to the said respondent. Stop. Further, since Ms. Lucino has also appeared on behalf of Mr. A. Aimi, A. Zimomi, London Standing Council, Gauhati High Court for respondent number 5, no formal notice need to be sent to said respondent also. However, the petitioner shall furnish requisite numbers of copies of writ petition along with the annexure to the London Government Council as well as Ms. Lucino, as well as London Council for respondent number 5 within
The course of the day.
in the course of the day. Stop. Let this matter be listed. The respondents may take necessary instructions before the next date fixed and may file their affidavit in opposition if they desire to do so. Let this matter be listed after
2 weeks.
2 weeks.
It can be after 4 weeks.
Since all the respondents have
We will have
entered the
get
periods.
instructions.
Let
And
it-
we are
let-
serving the copy in
4
course of the
weeks.
day.
Let it be 4 weeks.
That will be told long also.
Let them take instruction.
For admission, item number 3.
This lordship. My lord, in this standard petition, the petitioner is praying for regularization of service on the completion of 30 years of continuous service. On the basis of Office Memorandum 17/3/2015, my lord. My lord, the petitioner was appointed on 08/07/1991. Firstly, initially on a fixed pay as labor. Later on.
What was your date of initial appointment? 08?
08/07/1991.
Yes.
Later on 05/03/2021. Petitioner was granted scale of pay as work charge scholarship. My lord. Since then, my lord, the petitioner has been serving for over 34 years and is due to retire soon, my lord. And it is very clear in the OM, my lord, which is
Where is the OM?
at page 23, my lord, Annexure D. Page 23.
Yes.
This is a scheme for regularization and absorption of work charge and casual employees and revision of pay and wages. The relevant portion, my lord, paragraph 1 clause 1, my lord. Regularization in service. All existing work charge and casual employees of various departments who are enjoying scale pay and who have completed 30 years or more continuous service as on 1st January 2015 will be regularized by conversion of their posts into regular ones personal to them and subject to fulfillment of conditions as indicated below, my lord. These are the terms and conditions, my lord. Whereas, my lord, I'm allowed to take you to the affidavit in opposition regarding these terms and conditions, my lord. Affidavit in opposition filed by the respondent, my lord. Page 3. Page 3, paragraph 5, my lord.
Yes.
My lord, may I be allowed to read it?
Yes.
That with regard to the statements made above, made in paragraph 346 of the writ petition, the deponent begs to state that as per the OM 1703/2015, for a work charge employees to be regularized, she should have completed 30 years or more of continuous service and should be enjoying scale of pay. Thus, the petitioner, having fulfilled the criteria laid down in the said OM, his name, along with similarly situated work charge employees, have been forwarded to the government for regularization by letter dated 7 July 2022. And the names of the petitioner is reflected at serial number 2 under Kohima Rural Division, who have completed 30 years or more continuous service as on 1/1/2022. My lord, there is no doubt after verification by the department, the petitioner has been found a genuine and also eligible to be regularized, my lord. And my lord, the proposal for regularization of the petitioner have been submitted way back in 2022, my lord. But till then, no action has been taken, my lord. And the petitioner has completed 34 years of service.
When will you be retiring?
As per the report submitted by the respondent, my lord, the petitioner will retire on 31st August 2026, my lord. So, my lord, I pray that this honorable court may give a direction to regularize the service of the petitioner within a specific period of time, my lord.
How much? Suggest. You may make suggestion.
My lord, 3 months.
Okay.
Your lordship, months will be difficult, your
But
lordship.
he will retire soon.
But your lordship, he retires next year in 2026. And for regularization, the process is lengthy, your lordship. It has 4 stages to undergo.
Why it is pending?
Your lordship, first it has to obtain clearance from the PNR. Then again, it has to obtain the clearance from the finance. Then after that, it comes to the MRC where clearance is obtained, and then finally it goes to the cabinet for approval.
What is MRC?
Manpower Rationalization Committee.
Okay.
Yeah,
So
once-
now, at what stage it is pending?
At time of filing this affidavit, the only instructions that I had was that it was placed before the government. So after that, because that was way back in 2022. So your lordship, before disposing of him, if I may be given some time to get the latest update.
When will you be informing?
Your lordship.
Because this is, you are agreeing that he is eligible.
Yes, your lordship. That's why we have.
Only you are delaying the matter.
Yes, yes.
So a direction has to go. So when will you be taking that instruction? By tomorrow,
Your lordship, tomorrow will be difficult.
day after tomorrow? Otherwise, this case will slip.
Yes, your lordship. And if I may be given on Friday, your lordship. Just to get the instructions.
Okay, then I'll fix this matter for delivery of judgment.
On Friday.
No, I'll reserve this matter on Friday. You inform to this court.
Yes, your lordship.
Okay. Heard, Mr. What is your name?
Justin Ma. Justin Ma.
Justin.
Ma.
Justin Ma. This is item number? Justin Ma. M-A-G-H.
Yes.
How it is pronounced?
Ma.
Ma.
Yes.
Heard, Mr. Justin Mark, learned counsel for the petitioner. Also heard Ms. A. Aimi, learned government counsel, government advocate appearing for the state respondents. In this writ petition, the petitioner is seeking a direction to the state respondent for regularization of his services as he is eligible for the same in terms of the office memorandum of the government issued in the year 2004 as well as 2015. Stop. The learned government advocate, Ms. A. Aimi, has submitted that though the petitioner has been found eligible to be considered for regularization in terms of the aforesaid office memorandum. However, as the state respondent had filed the affidavit, no, however, she seeks, no, continue. Cut this line, however. She also submits that the matter has already been forwarded to the government for consideration. However, she is unaware about the present status of the said case. She therefore seeks some time to let this court know as to at what stage the matter of regularization of the petitioner is pending before the government. So considering this, I have heard learned counsel for both sides. Hearing is concluded. Let this judgment be reserved for, let this case be reserved for delivery of judgment. Stop. In the meanwhile, learned government counsel is requested to let this court know through the court master. You inform the court master because it will not be listed through the court master, on coming Friday, that is, which is the date? Friday. That is on 22nd August 2025, regarding the present status of the matter regarding regularization of the petitioner. Stop. You inform you give me that information. You can orally inform, even by mentioning also on that day. Instead of court master, though I have mentioned, you may mention before the court, oral mentioning. No written is required. Okay.
Nice approach.
For admission, item number 5.
One of the petitioner is applying for family pension. The husband of the petitioner was appointed annexure 1. Page 13. Type copy is 13A. This is executive engineer doing some.
Page.
Page 13 in the type copy is 13A.
Just a moment. Yes,
Mary Gottman.
yes.
This is dated on the 2nd February 85, my lord. Right side.
What is this appointment letter?
Yes, my lord, first appointment. In the interest of public service, such and such, Kim One, work charge labor is hereby promoted. It appears that it's a promotion, but as far as the petitioner is concerned, she knows only from this particular appointment date. As Masun helper for the period of 6 months under the establishment of this POPWP number in the scale of pay of such and such. Plus inner line compensatory allowance of 25% of basic.
This is on which date?
Date 2nd February 1985.
Where it is mentioned?
My lord, the right hand side, just after the executive engineer did the petition.
Okay,
Dated the 2nd February 1985.
okay.
So,
This is the date of promotion, not of your initial appointment.
as far as the petitioner is concerned, she knows only from this date. So it appears that it must be the date of appointment. That is what the petitioner is in the new appointment.
Okay.
So I think that this is appointment.
Or
One of the chances really typing.
no, it shows that he was appointed prior to this.
My lord, it appears. But the only document which have with the petitioner is this one. The petitioner is passing from this particular day,
Okay.
my lord. Then annexure 2 is page 14, type copy is page 14A. This is 1st March 1986, ma'am.
What is this? This is again promotion letter. What is,
This is the petitioner's husband hereby reappointed and promoted. So the word is promoted. As
Work charge Mason Hill.
yes, the word is same mason helper. It is same mason helper under the establishment of STOP Provisional earlier posting in the scale of rupees 375 malo. So same scale of it plus all other allowances as are admissible from time to time which it from the date of agreeing to the post. The appointment is purely temporary matter and liable to be terminated without any reason. So it's a, there is no stipulation for it's a regular appointment. It doesn't stipulate for us to say stuff.
Okay.
Then annexure 3, page 15. 15A is the type of this is 7th May of 1992. Would you allow to read? In the interest of public service, the Yaulai Kimuan of Nuklak Village, now working as worker mass helper all along from 1955. Second, before 1955, all along Mason helper is hereby promoted and appointed as work charge by it in the scale of such and such. The appointment is purely temporary and liable to be terminated without any preference. So it is a continuous promotion. Nomenclature is work charge.
Yes.
Then what do we do? In 2002, Malo, page 16, that is handwritten. 16A is type copy, Malo. To the Chief Engineer Housing, Interim, Kohima. Prayer for Regularization of Serviceman. Sir, I have the honor to state the following few lines of prayer for your kind person means sympathetic consideration. That, sir, I am serving as pipe fitter under the establishment of this TOP Provisional Club. Now it is, earlier it was a subdivision administratively, now it is a new district. Initially, I was appointed as a work charge laborer in February 1985. So one of the, as your lordship has pointed out in para 1, it appears that he was a laborer. But this is his, when he was alive, he made this clerical, clear statement. Sir, I am serving as a pipe fitter under the establishment of skill no block. Initially, I was appointed as a work charge laborer in February 1985.
Okay.
So what your lordship has pointed out, it appears from the representation itself that
But he was appointed in the year 1985.
yes. Since then, I am serving as a work charge appointee. I have completed the continuous service of 17 years. Having served for so many years, still my service is a work charge 1. Looking to this, I have to experience several difficulties. Moreover, I have been discharging my duties to the best of my ability in to the entire satisfaction of my superior official. In view of the above, state effect, I request your benign self to look into my case in compliance by regularizing my service. That is 21st August 2002. Hello.
We'll continue after lunch.
Hello.
May I please, my lord?
Yes.
May I mention item number 24, Lordship, in the concern of the counsel for the petitioners, Lordship. If this may be listed after 2 weeks, Lordship.
Lordship, I have been informed by my learned friend that the affidavit is ready. If that is correct, then let that be recorded because
Yes,
it is a retirement matter.
But he has to make submission. That
Yes,
it is
it's ready, Lordship.
okay. And Mr. KV Angami, Learned Government Council, appearing for respondent number,
State respondent number
appearing for the state respondent,
1 to 4.
who submits that the affidavit in opposition of the petitioners is almost ready and they require 2 weeks' time to file the same and seeks an adjournment on that ground. Also, Mr. C.T. Zamir, Learned Senior Counsel for the petitioners, as well as Mr. Joshua Sheki, appearing for respondent number 5. Any other counsel is there? No. Respondent number 5, who do not oppose the prayer of the petitioner. Hence, same is allowed. Let this matter be listed after 2 weeks.
Interim state that may be continued
The interim order shall continue
until
next day.
Your Lordship, if I may be allowed to mention item number 31 and 32, Your Lordship. Due to some unavoidable circumstances, my senior will not be able to appear with Your Lordship. We have taken consent from the other party, if the matter can come up on Thursday, Your Lordship,
Which Thursday?
day after tomorrow.
Mhm. It has to be next week, you choose a date.
Okay, the next Thursday,
Heard, Miss, what is your name?
Kim Piano.
Kim Piana, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. She also submits that she has informed the counsel for the respondent side, who has no objection to the prayer made by her staff. Hence, the prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
Lordship, Lordship.
Yes.
My lord, representation was not considered. In the meantime, what happened is that the employee died on 23/5/2005, page 17.
When he died, 23?
23/5/2005.
Okay.
To the present petitioner. In the representation, page 18. To the engineering chief. NPWD, starting prayer for family pension and other service benefits of my husband, late Yaldi Kimungan, alias 1234. Different names, but it all pertains to the petitioner husband. Work charge by FITRE. Sir, on the subject cited above, I have the honor to state the following lines for your kind consideration and necessary. That by office order number such and such, 2nd February 55, passed by the executive engineer PWD to Insang Division. My husband, such and such, was appointed as Masun helper for 6 months and by office order dated 1/3/1986, the scale of pay was increased to rupees such and such. That by office order dated such and such 1992, my husband such and such was promoted and appointed as work charge 5 fitted. In the scale of pay of such and such, in all other allowances are considerable from time to time in accordance. That after serving the department for more than 17 years, my husband led such and such, represented to the chief engineer housing PWD, Nakal Kohima for regularization of his service on 21/08/2002. However, the same was not considered, my lord. That my husband died on 23/05, leaving behind the 3 children, 1, 2, 3. My late husband was the sole bread earner of the family. The entire family has been facing untold hardship to maintain our livelihood. Therefore, I earnestly beseech your esteemed authority to kindly grant family pension in service benefits for the service of my late husband from 0202 of 1985 to 21. This is 5/8/2020. This is 2002, not 20.
Yes.
Dated 21/8/2023. Kim Sao, Srimati Kim Sao, wife of late Yolai Kim Wan. I may be allowed to take your lordship to the take it. One fact remains that the petitioner's husband was a work charge all along, even though promotion, whatever you have been given. So I may be allowed to take you to CCS pension rules 1972, page 20.
Page 20.
Yes.
Yes.
Mr. Saran.
Yes.
Application safe as otherwise provided in this rule. This rule shall apply to government servant, including civilian government servant in the defense service appointed, my lord. Substantively, the petitioner's husband is not substantive to the civil service and post in connection with the affairs of the union, which are born and pensionable establishments, to work charge. Two, it is not substantive. However, Government of India's orders are given. Since later on, my lord. Bracket 1, my lord. Grant pensionary benefits to temporary government servants retiring on superannuation, invalidation, and completion of 20 years. Now it is 10 years. Temporary service. In terms of Rule 2 of the CC's Rules 72, a government servant, including a civilian government servant in the defense service, appointed substantively to a civil service post in a pensionable establishment is eligible for grant of pension in DCRT. That goes without saying, here in error. A government servant who at the time of retirement from service does not hold a leave on a permanent pensionable post is not eligible for pension in PCRT, but is eligible for terminal gratuity under such and such of the CC's Temporary Service Rules 1965. Now the question is, the question of grant of pension to government servants who retire after long years of service without being confirmed in any post has been under the consideration of the government. It has been decided that the government servant who in his retirement from service and attaining the age of superannuation or and is being declared to be permanently incapacitated for the government service by the appropriate medical authority after he has rendered temporary service of not less than 20 years, now 10 years, shall be brought within the purview of CC's pension rule 72 in the condition, holding a pensionable post in a substantive capacity shall be dispensed with in his case. And consequently, what will happen is such a government servant will be eligible for the grant of superannuation or invalid pension, TCRT, and the petitioner's family pension in accordance with the provision of the aforesaid clause. Then Page 52. Terminal benefits. In partial modification of certain sites, 1980, quasi temporary who retire on superannuation or on being declared permanently incapacitated for further government service. Whether appropriate to withdraw to the other temporary service of not less than 10 years. Shall be eligible for grant of superannuation, invalid pension, retirement gratuity, and family pension. Then, again, this is bracketed 3. Numeral 2.
Yes.
Death benefit in the event of death in harnessment of temporary quasi-permanent government servant. Your family shall be eligible to family pension in TCRT on the same scale as eligible to family of permanent government servant under 72 rules. Then page 23. OEM 26 November 2009. Such counting of contract auto period for retirement. Many departments have sought clarification as to whether the service rendered by an employee on contract auto work charge, deputation husband. Appointment should be counted for fixing of length of service. The standing guidelines of the government is that the period of such service rendered is being counted for increment, leave, pension, and other service benefits, except seniority.
Yes.
Then the next line is about those who are regularized. In the present case, not regularized. So regularized work charge employees are also entitled to count in full their continuous work charge service towards pension benefit. So it is all the same. One thing is about the pension. Whatever be the nature, that period has to be covered. Can oriented. This is 2010, 15 February 2010. Page 24.
Yes.
Counting up adults period for retirement. So just say that the disease continues. Then all the work charge period will be counted for retirement.
Okay.
Last part is very clear that the length of service provided that the employee has been allowed to count the former service period for the purpose of leave, pension, etc. Not the seniority. Then page 25, annexure 10. This is scheme for regularization in absorption of work charge in casual employees. The present petition is not directly related to this, but however, one fact remains. Regularization in service. F. 1, Roman 1, A, B, C, D, F.
Yes.
The past service rendered as work charge in casual employees shall be counted towards length of service for the purpose of retirement from public employment. 2009 in other qualified service for the purpose of pension. That is clear, my lord. My lord, government filed a affidavit in opposition saying that he is not eligible for regularization. Goes page 7 of the government affidavit. Annexure 1, page 7. Fit there. Page 7. Among
Yes.
the fit there. Yes. Serial 6. 3 Yao Lai. Then column 7 is date of creating in the initial treatment, which is 2/1985. But if unit as 1/3/1986. This is not correct. So this will not be used because we have not denied about the appointment notice. So this cannot be the correct position.
Which is not correct?
No,
Which one is not correct?
among the date of creating in the initial grade, that is column 7.
Date of joining.
Yes, it is shown as 1/3/1986. Yes. Which is the correct position should be. This is promotion to Peter.
Okay.
First appointment is your lordship as meet the query. Annexure 1 to the writ petition is 2/2/1985.
You are referring to the affidavit filed by 1234.
Mine. This is government. Look, what I'm finding is not that. Only the thing is that initial date of trading is not shown correctly. That is what I'm saying.
Okay.
So I found the affidavit in reply. Well,
Yes.
on 6/8/2025.
Yes.
What I'm stating is that the question of that OEM for regularization will not be applicable in the case of the dead who died in harness. As it is clearly given in this honorable court judgment in order of Pradeep Chakrabarti versus State of Assam in Adjournment, which I annex as Annexure 11, page 5 of my affidavit being written. This is Honorable Court Order GLD 2014-1 GLD 617. In interesting part,
Page number?
page number 5 of my affidavit being written.
Yes.
Well,
Which
here-
para you are relying?
What I'm trying to say is, this was not a single petition decision, madam. Practically, it is 65 numbers of petitions. Decided by this honorable. 65, madam.
No, in this judgment, you are relying on which paragraph?
One of the para 2. Para 2, running page 9. The
Yes.
core issue involved in this batch of writ petitions, madam, is the claim of workers, employees, master role workers in similar category of employees engaged prior to 1/4/1993 for regularization of their service under the government assembly related grievance. Related grievance will come in the present case. Related grievance, which can also be said to be an offshoot of the core issue, is the claim of such category of employees in workers or the family members for pension or family pension as the case may be, madam. After attaining age of superannuation or, madam, in the case of death, by creating supernumerary posts personal to the incumbent in regularizing his service for 1 day. Then, madam, para 66, madam. Page 9 of the running page. Summary in conclusions, madam.
Yes.
Then, from 66, let me take to 32, 9. Page 30. Bracketed 9. Neither Uma TV nor Jitendra Kolida bar application of the past practice of creating supernumerary posts in regularization for 1 day of the work charge must roll in similar category of employees engaged prior to it was Asamisio 1/4/93. After attaining the age of superannuation or in case of death for the purpose of grant of pensionary benefits, madam.
Yes.
Then, 2019, then SCC 516. This is a home-page decision, madam, of the Supreme Court.
What it said?
Madam, what we see is that para 5, this court in other cases has followed the appropriate decision in Habib Khan. This, Malord, there are 3-sided case in this whole bench, which was cited by the whole bench. This court in other cases has followed the opposite decision in Habib Khan versus Uttarakhand, giving relief to the employees. In Ramdev Tiwari, state of such and such, decided on 16/3/2018, the decision of Habib Khan has been followed. So, my lord, I may be allowed to take your lordship to the cited portion first, which is clearly followed by the full page.
Which para?
Cited what, my lord? Cited order what? That is Habib Khan appellant versus state of Uttarakhand. Page 543, para 3. The period of service rendered by appellant was directed to be counted for continuing qualified service for purpose of benching by the State Public Service Tribunal. The writ petition such and such order was dismissed. The petition for special leave filed by the state against the order of dismissal of the writ petition was also dismissed by this court. In between, a full page of Uttarakhand High Court took the view that the period of work service did not be counted for competition of period of qualifying service. On the basis of the opposite decision of full page of Uttarakhand, my lord, review of the order dismissing repetition such and such was sought by, which was allowed by order dated such and such. The said orders dated such and such was challenged before this court and was dismissed as withdrawn. In the meantime, on the basis of the order passed in the review petition, the matter was reheard in the High Court by order dated such and such, held that the period of work service cannot be counted for reckoning the period of qualifying service. While order such and such is the subject matter of the challenge in appeal arising out of SLB such and such, and in appeal arising out of SLB such and such, the order of the full page is the subject matter of the challenge in appeal arising of SLB number such and such. Para 6. The parimatria provision contained in Rule 3.7 of Punjab Civil Services had been struck down by full page decision of Punjab and Haryana High Court in Kisarjan versus State of Punjab. The challenge by the state against the opposite decision of the full page of Punjab and Haryana High Court was negated by this court. The matter came up for consideration before this court once again in Punjab ECB versus Narada Singh. While dealing with the said question, this court, para 25 of the report, held that the full page decision of the Punjab and Haryana High Court was perfectly justified in striking down such and such a Punjab service rules, resulting in obliteration of the distinction made in the state rule between temporary and officiating service and work charge service. On the said basis, this court took the view that the period of work charge should be reckoned for purpose of competition of qualifying service for grant of pension. 7. As already observed, the provision of regulation such of Uttarakhand are very material with the provision of rules such of Punjab services. So this is Punjab as well as in Uttarakhand. Decision is it should be counted. If that is so, we do not see as to why the period of service rendered on workers' basis by the appellant should not be counted for purpose of compensation of qualified service for grant of pension. So, maloko. Then the state file a review before the Supreme Court. That is next side 2. State of Uttarakhand in other verses of the plan. Pension, service law, pension, work charge, employee review order dated such and such, held that wherein it was held that the period of work charge service will be recorded for purpose of competition of qualifying service for grant of pension. Prayer for review dated matter. Then cited order 3, run UPY. Heading service law pension work charge employee period of work charge service following Habib Khan held prior period of work charge service must be recalled for purpose of computation of qualifying service for grant of pension. Para 2 is that 14. The learning council to the applicant brought volunteers to judgment order Habib Khan. We connected the measure where he spoke and held that the period of work charge service must be recalled for the purpose of computation of qualifying service for grant of pension. We are in this stakeholder agreement with the affirmative this. And after taking into account of all these 3-sided cases, the 4 pages comes to the conclusion, page 55, madam. One.
Page number.
Running page 55. Para 11 of Bracing. Merito.
Yes.
31 in the opposite facts is circumstances. It was unclear on the part of the state government and it's official to take the work from the employees on the work charge basis. DO2 have resorted to an appointment on regular basis. The taking of work charge on the work charge basis for low amounts to adopting the exploited device. Later on, through your services have been regularized. In my case, no. However, the period spent by them in the work charge establishment has not been counted towards the qualifying service. Thus, they have not only been deprived of their due emoluments during the period deserved unless salary in work charge establishment, but have also been deprived of counting of the period for pensionary benefits, as if no services have been rendered by them. The state have been benefited by the services rendered by them in the heydays of their life unless salary in work charge establishment.
Okay.
33.
Yes.
The question arises whether the imposition of right that such service to be counted has to be rendered in between 2 spells of temporary or temporary and permanent service is legal in proper. We find that once regularization has been made on vacant posts to the employer not served prior to that temporary basis, Considering the nature of appointment, though it was not the regular appointment, it was made on monthly salary. And thereafter, the pay scale of work charge establishment efficiency power was permitted to be cruised. It will be highly discriminatory and irrational because the writer contained in note such and such not to count the service, particularly when it will be counted in case of such service is sandwiched between two temporary or in between temporary and permanent. There is no rhyme or reason not to count the service of work charge period in case it has been rendered before regularization. In my case, no, not regularization. In our opinion, it is impermissible. Classification has been made under such and such, it would be highly unjust, impermissible, and irrational to deprive such employee benefit of the qualifying service. Service of work charge period remains the same for all the employees. Once it is to be counted for one class, it is to be counted for all to prevent discrimination. The classification cannot be done on the irrational basis in when respondent are terms of counting the recipient in such service. It would be highly discriminatory not to count the service on the basis of plain C classification. The writer both on that work charge service should have preceded by temporary capacity is discriminatory, irrational, and creates an impermissible classification that follows the writing, the last sentence. Then, para 36 months.
Yes.
There are some of the employees who have not been regularized in spite of having rendered their service for 30 to 40 or more years. First, they have been suffer unwaiting as they work in the work charge establishment, not against any particular purpose. Those your service ought to have been regularized under the government under instruction. And even as per decision of the state of Karnataka versus Umati. The petitioner's husband died before decision of the Umati, but still then this covers it. This court in the same decision has laid down that in case services have been rendered for more than 10 years, in the petitioner's husband case also more than 50. Without the governor of the court's order as one-time rental services, be regularized of such employees. In fact, some the case, those employees who have worked for 10 years, reiterated, or more should have been regularized. It would not be proper to regulate them for consideration of regularization as others have been regularized. We direct that their services be treated as regular work. That is clear. However, the writer it is made clear that he shall not be entitled to claiming any use of the difference in wages that he will continue in service regularly before attaining the age of superannuation. In my case, then he shall be entitled to receive the pension as if he had retired from the regular establishment and the services rendered by them right from the day he entered the work charge establishment shall be counted as qualifying service for purpose of pension money. So my prayer is that my prayer portion, page 11. My prayer is to regularize the service of date such and such, that is the petitioner's husband, from 02/02/1985 to 23/05/2005. That is the date of death. is to pay family pension in service. That is my full prayer, much obliged.
Your Lordship,
Yes.
in my affidavit, paragraph number 5 and 6. In 5, I have stated that there is no state government policy for posthumous regularization. Moreover, at the time of death of the petitioner's deceased husband, he was not entitled to regularization as he was much below in the seniority list. He was at serial number 6 in the seniority list. Thus, his case could not be regularized as there were other seniors employees before him, Your Lordship. Now, if we look at the seniority list, under the category of fitter, his name is at serial number 6. Now, the date of
Page number 6 or 7?
Page number 6 is the first page, and the 7 is where the petitioner's name is listed.
Yes.
Page number 7, column number, the last column. The last column, that is with regard to appointment order and date in the present grade. So when this seniority, the list was out, he was working as a fitter, Your Lordship, fitter. So that's why his name is shows at serial number 6. And the date of joining the present post is marked as 5/7/1992. That is column number 7. So, Your Lordship, this seniority list has no discrepancies. Moreover, Your Lordship, the regularization policy, OM dated 22/9/2004. In para 4, it clearly states that regularization will be considered on the basis of seniority cum merit, Your Lordship. Your Lordship, and in support to my submission, I rely on the judgment passed in WPC number 102 of 2019, where the court has made the observation in paragraph 3. That is the last page, page 4, if I may be allowed to read. This is also a similar case with the petitioners, Your Lordship, posthumous regularization. If the husband of the petitioner was not entitled to regularization during his lifetime, the question of issuance of a direction to the authorities for granting of regularization posthumously does not arise, Your Lordship. And with regard to Nishevi's case also, Your Lordship, even in this case, in Nishevi's case also, one of the ground that the petitioners was denied regularization was because, Your Lordship, at the time of death, the deceased employee, his seniority was way below in the seniority list, Your Lordship. So relying on Nishevi's case and in WPC 102 of 2019. That's all, Your Lordship.
As far as the respondent number 9, the office of the principal, the establishment of the principal accountant general is concerned, regularization has got nothing to do with us. And even seeking pension also, until and unless the paper is processed and it reaches the office of the accountant general, our job is only to approve, to see that the documents are in a clear format or the claims made are proper or not. So, Your Lordship, in this case, we have nothing to say because the file is yet to reach us. In fact, we wanted to be strike out in this case also, to be struck out. But the same was not considered.
Whether he will be entitled to pension or not, the decision has to be of the state government.
Yes, Your Lordship.
Only after it processes.
My Lord.
Okay.
Your Lordship.
The learning government advocate raising the question of Delhi, I admit to that. But one fact remains. My writ petition para what? The petitioner belongs to Kimongan. Your logic will not be that clear about the situation. But Kimongan tribe, which is a scheduled tribe of India, Kohima and officially declared tribe in the state of Nagaland. Apart from a scheduled tribe, the present petitioner, which belongs to Kimongan, it's a declared backward tribe, even in the state of Nagaland. Meaning they are totally educational backward. Socially,
How it helps you?
my lord,
How?
what I'm trying to, my lord friend has reached the issue of approaching Delhi. So I accept to that. Well, they can do the somebody. If the petitioner is approaching your lordship now, so I understand that.
No, her main contention is that there is no provision for posthumous regularization. Second is that your seniority is way
below.
Way below.
Yes.
These are the main good.
If the petitioner husband continue,
You would
He
have
will-
attained the
he will
seniority.
come under that scheme for regularization.
Okay.
But as far as the Krishna family pension is concerned, it's very clear on that line. Pradeep talk about it. It's for the family pension. That is very clear. So the whole page of this honorable Supreme Court is clear that it has to be counted for pension. That is family pension.
Okay, heard. Mr. Inti Lonchar, learned counsel for the petitioner. Also heard Miss A. Aimi, learned government counsel appearing for respondent number
128.
128, as well as Mr. Joshua Sheki, appearing for respondent number 9. I'm reserving it. The hearing concluded, judgment reserved.
For hearing, item number 29.
Many matters are there. In more matters. What is this matter?
This is a case also from school education department, Lodge. In the school education department, there are many categories of service. This case pertains to the teachers. In 2012, the government had decided to upgrade the high schools to that of higher secondary schools. So in view of that policy, the class 11 and 12 has been upgraded in many schools. So subsequently, the teachers are required to be posted. But there were dearth of teachers, less number of teachers so as to cope up with the change policy. So what the department had decided, the government has decided, it's a policy decision of the government for upgradation. So accordingly, a policy decision was also taken by the state cabinet to give some incentive to the persons, teachers who are postgraduate, but they are working as graduate teacher and primary teachers, although their qualification is
That-
postgraduate.
Okay.
So the policy decision was taken to give some incentive to those persons and upgrade to that of postgraduate teacher so that they can.
Postgraduate teacher in higher secondary school.
Yes, so that they can teach in the higher secondary.
Okay.
But there was some problem. Impediment was there. That was those persons who are postgraduate, many of them do not possess B.Ed degree, which is a mandatory requirement for the teacher because
Of higher
we are
secondary.
governed by the rules. Now, government has given a concession to obtain B.Ed degree, B.Ed qualification within a period of 5 years. And the institute where they are to avail this training
5 years of what?
for obtaining B.Ed Bachelor of Education.
5 years from which date? 5 years of their appointment as
No, from the date of upgradation.
upgradation.
Yes. So 5 years period was given. During this period,
They
you
have to
should
obtain B.Ed.
B.Ed.
Okay.
Actually, B.Ed course may be 1 year, 2 years, but then the institute where the training is imparted, the seats are limited. So all of them cannot be accommodated at a time.
Therefore, 5 years.
Therefore, yes, relaxation was given. In 2013, I believe, yes, the school education department has taken the state cabinet has taken a policy decision to upgrade those primary teachers and graduate teachers who possess postgraduate degree. So they were upgraded to data postgraduate teachers.
Okay.
During that time, when this decision was taken, there was no senior postgraduate teacher or junior postgraduate teacher. But in 2017, when the new service rule was framed, giving a view of the Right to Education Act and all these things provisions, they have met two category of teachers, that is postgraduate junior grade and postgraduate senior grade. That was made by 2017 rules only. Now,
Okay.
on 19th of June 2014, Cabinet has taken a decision to upgrade 262 graduate teachers and primary teachers to that of postgraduate teachers. That was on 19/6/2014. Now, in 2014, pursuant to this policy decision, a batch, a group of teachers, they were given the pay scale of 4,600.
Group of teachers out of these.
Out of 262,
Okay.
a group of teachers, they were upgraded on 7th of July 2014 to that of postgraduate teachers. And by that, past benefits were also given, except seniority. So what happened, Lordship? In 2020, the present petitioners, who were 59 in numbers, but at present they are only about 52 only.
What
They are
happened to
petition number. You were upgraded in 2020.
52?
and then-
What happened to 7 others?
They are not coming before this normal court.
Okay.
Although they belong to the same group, they have not joined with us, joined with the petitioner In the meantime, some expired, some has also got some alternative jobs like that. So the present petitioners are 52 only out of 59 who were upgraded in 2020. So when they were upgraded in 2020, the government order says all the service benefits shall be granted, pension, all this pay, everything, service benefits is protected except seniority. Seniority is not an issue here. But the service benefits have been protected. All service benefits are protected. Now, after the framing of 2017 rules, the service rules, since our upgradation is in 2020, government department says that look, in 2017,
Rules are there.
rules have been framed. As per the rule, you are not eligible to enjoy a great pay of 4,600. You are only eligible and entitled for 4,400. That was the decision taken, ruling given by the directive. Now, our contention is, look, our upgradation is based in a policy of the cabinet, state cabinet, which was taken in 2014.
Prior to the rules.
Yes, prior to the service rule came into force, and the earlier batch of 2014, they were given 4,600 great pay. Basing on the same policy of the government, although we were upgraded in 2020 only, we are also entitled to enjoy the same great pay of 4,600 instead of 4,400. Why? Because the upgradation order of the government says that all service benefits shall be protected except seniority. We are not claiming seniority, so we should also get 4,600. That is the sums and summary of my case. There is disparity among the similarly situated
No,
persons.
what great pay was given to you? What?
4,400.
4,400.
Yes. And the contention of the state is, look, as per the service roll of 2017, you are entitled for this. But then our upgradation in 2020 is much after the service roll came into force in 2017. And knowing fully well that there is a provision in the service roll, our service benefits have been protected in our upgradation order, but by filing affidavit in opposition by the state, they try to develop their case in such a way that they are banking on the rules, and then as per the rules, it has to be in this, so you are not entitled. But my submission here is, yes, there is a rule of 2017. What the government is saying is correct in the sense that this rule will be applicable only to those persons who are appointed after the enforcement of the rules. Their great pay will be 4,400. But so far as our upgradation is concerned, it was during a time when the service rule of 2017 was not there. The cabinet has taken the decision in 2014 where our pay has been given 4,600. So that is the summary of my case. Now let us go to the relevant documents, what the different government orders says. Can we come to page 21? This is the upgradation order of the first page, because there are two pages. One is of 2014, the other, which is the petitioners, they belong to 2020 batch. In between, in 2017, the service rule came into force. And the government is banking in the service rule, and by banking in the service rule, our rights have been deprived. And how it is deprived, let us see. Page 21, Lordship. This is an office memorandum of 19 June 2014. Office memorandum, minutes of the cabinet meeting held on 17 June 2014. The undersigned is forward herewith an extract of the minutes, agenda 4 of the cabinet meeting held on 17 June 2014, for kind necessary follow-up action. Good. Agenda 4. Proposal for upgradation of government high schools to government higher secondary schools under the School Education Department. The Cabinet examined the proposal for upgradation of proposals of the School Education Department for upgradation of government high schools to government higher secondary schools and decided the following. 1. The Cabinet approved the proposal for upgradation of 22 schools as proposed by the department. The Cabinet also agreed to include Mundaun, the government high school, for upgradation to higher secondary level. 2. The Cabinet approved the proposal of the School Education Department to change the name of government high schools, Chibobuzo, appearing in the list of high schools approved for upgradation to higher secondary schools as government higher secondary Chichama Chibobuzo. Number 3, we are concerned with this. The Cabinet agreed for upgradation of 262 posts of graduate teachers, primary teachers, to the level of postgraduate teacher, after identifying the in-service teacher having the requisite qualification. This is important. Paragraph 3, Lordship. Selection and appointment of the teachers shall be need-based and shall be taken up in a phased manner, corresponding to the upgradation of the schools to class 11 this year and to class 12 next year, unquote. Action taken on the matter may kindly be intimated to the Cabinet. So this is the policy decision of the government. Based on this, there was a page of 2014, and based on this same order of the Cabinet, we were also upgraded in 2020. So kindly come to the next page, but it is not clear, so type copy Lordship will find at page 23. This is the appointment after the upgradation. This is 7 July 2014. May I read, Lordship?
Yes.
In the interest of public service, the Governor of Nagaland is pleased to appoint the following graduate teachers and primary teachers under the School Education Department to the post of postgraduate teachers, history, under higher secondary education, class 11 candidate, class 2 candidate, sorry. In the scale pay of so and so, the pay is last, pay of 4,600 per month with immediate effect. List of teachers along with place of posting enclosed as Annexure A. Paragraph 2 will be important. Seniority will be counted from the date of conversion. This is important. From the date of conversion of the post of postgraduate teacher through Departmental Promotion Committee, service rendered in the past shall be counted for all other service benefits except seniority. This will be very important, Lordship. Except seniority, all past service benefits shall be protected. That means for a government servant, pay. I believe this is one of the most important service benefits. So the past service benefits have been protected by this order.
What was the past service benefit in respect of pay? Your earlier pay was different.
My pay is 4,600. And that should be protected. Whatever pay.
No. When this notification was issued on 7th of July 2014,
Lordship,
it is speaking about the benefits which accrued to the persons before this notification.
on the day of this order, that is 7 July.
Yes.
So they were enjoying this pay scheme, 4,600. So it is given. This order has conferred the rights and the service conditions to be regulated as per this order. This order is not superseded till date, and government have not denied this order also. So this order is the basis of granting great pay of 4,600.
Yes.
And this condition is further confirmed and affirmed by the upgradation order again. We will go to that. Now, can we come to page 24 is the approval of course, that copy is in 25. Because cabinet has taken a decision with post facto approval, because it is need based. It has to be done urgently. So subject to the approval of the PNR and the finance, they have already given their concurrence in 2015 itself, both by the finance as well as the PNR. Dates lordship will find in the bottom of the page and page 25. It is 19/5/2015. So this is, and the finance concurrence clearance. Concurrence lordship will find it page 26. That copy lordship will find it page 27. That copy is more clear. So the proposal for upgradation, all these were approved by PNR as well as the finance department. And in page 27, lordship will find towards the bottom, Roman 3, just below that. This has concurred by finance department number so 1/6/2016, before the service rule came into force, subject to the following conditions, and then 2 conditions are given. And then finance department observation is at page 28. That copy lordship will find at page 29, which is more clear.
Yes.
By filing affidavit, government has subsequently came with a plea that this finance department is an error. This order is an error, so we have rectified.
What error?
But the government affidavit do not say that the notification of 5/3/2020, which I have shown to your lordship, I will show at page 30 and 38, are not errors. After filing the writ petition only, government tried to rectify their mistake. This was on 2012/2017. In the bottom of the page, lordship will find.
Yes.
And after filing the writ petition only, government came with a plea that this is an error, so we have to rectify. But in 2020, after the service rule came into force, few orders were issued. Can we come to page 30?
Yes.
It's a short order, so may I read?
Yes.
This is 5th March 2020. In the interest of public service, the Governor of Nagaland is pleased to permanently upgrade 16 posts of graduate teachers and 43 posts of primary teachers to the post of postgraduate teachers in the level of level 11, that is 40,800 in the pay matrix under the School Education Department as per Annexure A. Number 2. This issues with the approval of the Cabinet by 19 June 2014. This is very important. This date, 19 June 2014, and is ex post facto clearance by the PNR Department dated 19/5/2015. This is also important. 19/5/2015. This is the clearance of the PNR, and the concurrence of the Finance Department dated 1/6/2016. Policy decision was in 2014, and the clearance of the PNR was 2015. Finance concurrence was in 2016. So all this were done prior to the new service rule came into force, and we belong, this is our appointment orders. And in paragraph 10 of the writ petition, we have given the particulars of the petitioners. Paragraph 10 of the writ petition, there is a chart in page 31 in which serial numbers of these orders are there. In order to simplify, we have given a chart in paragraph 10 of the writ petition. where the serial number of the petitioners, incumbency list, what is the number, everything is being shown in paragraph 10 of the writ petition. The chart which is shown in page 31. To simplify, because all the persons are not the petitioners here. That's why in paragraph 10, a chart has been prepared and it is projected there. The serial number of the petitioners and their particulars. Page 34, 35, 36, 37 are the posting orders, so that will not be relevant, Lordship, because that is not in dispute. The most important document is page 38 again, Annexure H. This was issued on the 5th March of 2020. I was referring to the upgradation order at page 30. That date is 5th March 2020. And in page 38, the notification is also of 5th March 2020. This is the effective upgradation order. Lordship is on page 38.
Yes.
Yes. May I read, Lordship?
Yes.
Consequent upon the upgradation of 59 posts, these are petitioners, Lordship, of graduate teacher and primary teacher to the post of postgraduate teachers by notification of event number 5th March 2020 and under recommendation of the screening committee, the Governor of Nagaland is pleased to upgrade the following incumbents along with the post in order of merit to the post of postgraduate teachers in the level 11 of biometrics 40,800 so and so under the School Education Department as per Annexure A. 2. Seniority in the higher secondary cadre will be counted from the date of accreditation to the post of postgraduate teacher. Service rendered in the past. This is very important, Lordship. Service rendered in the past shall be counted for all other service benefits except seniority. So here also the similar order with that of 2014 page. Past service have been protected. Service rendered in the past shall be counted for all other service benefits except seniority. So seniority is not given, it's not protected, but all other service is protected. So the pay is also protected. Past benefits includes the grade pay. Otherwise, if we are to interpret that, no, we have not given, then what is this order? Service role has not barred us to enjoy grade pay of 4,600 also. There is no provision, nowhere in the service role that we are not entitled and eligible for 4,600. It is only the interpretation of the government that banking and the 2017 rules, they are trying to bring a theory so as to deny the benefits to the petitioners, Lordship. Certain conditions.
In 2017 rules, the pay structure is 6,400 or 600?
Pay level 11, they have given this.
Yes.
Is 4,400. This has created the confusion. It should be 12.
For
this order, since this order has been issued after 2017 service rule, they have given pay level 11. But then at the same time, in your own order, they are saying that the past services rendered in the past shall be counted for all other service benefits. So all other service benefits means it is counted already by the order of the government, except seniority. Only the seniority was not given. So our service is to be regulated in terms of this order by protecting all the past service benefits. Therefore, the petitioners are entitled to enjoy and protect the service benefits in terms of this order. Lordship is well aware that the pay is the most important component in the service. So when past services are protected, pay is protected. And as I was mentioning before also, all proposals, all correspondence, all clearance done prior to 2017. As I have already referred to your lordship. And government in their affidavit has never said that the notification of both notification of 5th March 2020, one in page 30 and the other at page 38. Both orders are 5th March 2020, that is with regard to the upgradation order. In government affidavit, nowhere they have stated that this is an error. The order and notification of 5th March 2020 is an error. They are only trying to twist and interpret. But this is the order which has protected our past service benefits.
Now what pay metrics you are getting now?
I'm getting 4,400 now. So
Not
we are
not
claiming-
this 40,000
that is the
level
total
11.
developments. But as per pay level 11, so it goes to grid pay 4,400. So in our prayer, if we succeed, we have claimed for area pay also, and we are entitled because everything has been done prior to the service rule came into force, and whatever government contingencies are coming is to be applied to the fresh appointees who are appointed after the service rule of 2017. Yes, whatever government is saying is correct if it is to be applied after the enforcement of the service rules. Service rule was enforced sometime in November 2017, notified in the Gazette.
Okay.
Government never said in their affidavit that 5/3/2020 is an error. So long as the government order stands, we have to go by that. And in paragraph 4, Lordship will find clearly this issues with the approval of the cabinet by so and so 19 June 2014 and ex post facto clearance of pioneer department and the concurrence of the finance department, that is 1/6/2016. So upgradation, everything is based in the cabinet decision of 19 June 2014, and then the clearance of the pioneer, concurrence of the finance department, all are prior to 2017 service rules. And based on this 5th March 2020 order has been issued, and the government has not said in their affidavit that this is an error.
Okay.
And these two orders have protected our past services, except the seniority. All service benefits have been given. Therefore, our pay has to be regulated in terms of the cabinet decision, pioneer approval, and the finance concurrence, Lordship. And thereafter, Lordship, we have submitted representations. Page 65 is the type copy. Since I have made the submissions, all those points we have mentioned in the representation. Now, government has written a letter to the Principal Director of School Education on 9 March 2021. At page 67, Lordship will find. I am directed to refer to the subject cited above and to forward herewith the representation by the upgraded PGTs of 2020 copy enclosed. The representation has been examined by the government, and since the service rule of 2017 supersedes all other provisions, notifications issued prior to that, their demands for placing them under the all grade pay of 4,600 is not tenable. But since they were upgraded along with their post, their pay has to be protected. In case their pay has not been protected, you are kindly requested to protect and fix their pay as per the rules and convey the decision to them at the earliest. So slightly confusing also.
If
And
pay
one-
is to be protected, that then the earlier pay which you were getting,
4,600.
that has to remain.
Yes. That is what, but at the same time again, the government is also referring to the service role. Service role has superseded everything. But then in the second paragraph, but since they were upgraded along with their post, their pay has to be protected very clearly, in clear terms. Therefore, Lordship, what I want to emphasize here is the enforcement of service rule of 2017 should not take away our accrued rights, which we have accrued on the strength of the cabinet decision, on the strength of the fair and air clearance, on the strength of the finance concurrence prior to enforcement of 2017 rules. Our pay has been protected and we have been enjoying 4,600. And then the old existing pay was 4,600. And another very important aspect, Lordship, service role have not part to enjoy great pay of 4,600. Nowhere said in the service role that we should get this much only. But only the department is depriving us. And Lordship has said in page 30 and 38, that is notification of 5th March 2020, government has also granted us the benefit. The benefit is all past service benefits shall be protected. That is 5th March 2020.
Yes.
An order issued by the government. Therefore, our pay has already been decided on 19/6/2014, prior to the service rule of 2017. We are also senior postgraduate teacher as per the service rule.
What this notification dated 5th March at page 30,
Yes,
how it is different from 38?
no different. This is 38 is a consequential order.
Okay.
Both the orders have conferred us the right.
Okay.
One point to be clear in mind. When the post held by us has been upgraded to that of postgraduate teacher, there were no senior, junior, grade 1, grade 2. Senior, junior, grade 1, grade 2 are all creation of 2017 service rules. Therefore, our upgradation order in 2014, the policy decision of the government, by that it was decided to upgrade. All benefits were even protected even after enforcement of 2000 service rules. Therefore, the contention of the government banking on the 2017 service rule may be applicable to those persons who are appointed after enforcement of the service role. If a person is freshly appointed to the post of postgraduate teacher, he will be treated as junior postgraduate teacher and enjoy a grade pay of 4,400. Strictly in terms of 2,000 service roles. And I would like to submit one important point, Lordship, on the principle of law.
Yes.
The application of service rule is always prospective in nature unless it is specifically mentioned in the service rule that it will have retrospective application from a particular date. The
Yes.
present service rule is prospective in nature. There is nothing in the service rule of 2017 that it will have retrospective application. Therefore, Lordship, my submission is the entire contention of the government taking on the service rule and denying our rights is contrary to their own order, and it's contrary to the service rule also. Service rule has to be applied with effect from the date when it is published in the Gazette, and any fresh appointment, yes, what the government is saying now is correct. And an order, any order, has to be judged and determined on the basis of what is there in the order itself. And the government cannot develop or multiply by way of an affidavit. Government, in other words, government cannot improve their case, modify their style by way of an affidavit.
Yes.
Mahendra Singh's case, 1978 is very clear. So what the order of the government says of 5th March 2020, 2 orders. These 2 orders have protected our accrued rights. That is, all the past service benefits shall be protected except seniority. We are not claiming
So
seniority.
it includes pay protection of.
Yes. And if they say pay is not there, then what is the benefit of a government servant? Number one benefit will be the pay. For that, all the government servants work. I did not have the opportunity to work as a government servant, so I don't have that experience. But anybody who is in the government service, at the end of the month, they are waiting for the salary. For that, they are working for 1 month, whether big or small, working for salary. And that is the service benefits. And the government order says that. Of March 2020 order says. And on the strength of the said cabinet decision of 2014-19 order, one batch of 2014 batch, they are enjoying 4,600 grade pay. Only we were given 4,400 grade pay. Whereas all of us upgradation was made basing on the 2014 cabinet decision only. So on the strength of the same cabinet decision, we were all upgraded, but we are treated differently. So there is disparity and discrimination by the respondents' Lordship.
Yes.
I believe that should
Okay.
be enough.
Yes, Ms. Levikan.
Thank you, Your Lordship. Your Lordship,
Yes.
I have filed 2 affidavit, Your Lordship. One affidavit opposition, and there was a direction from the dishonorable court to file additional affidavit. And therefore, there's another additional affidavit. It will be a little bit bulky, Your Lordship.
Just,
Affidavit in opposition,
yes.
additional affidavit.
Affidavit in opposition is very bulky.
It's filed on 23rd July. Not the first one, the second one. The second one is filed on 23rd July.
First one is 15. Twenty-third July. And if you. Yes,
Yeah,
I got
you got it?
both. Yes. Yes,
Yes, Your Lordship. So my senior counsel has already apprised this honorable court on the facts. However, Your Lordship, I would also like to draw your attention little bit to the facts, Your Lordship, because my interpretation of the fact and the interpretation of the fact given by my senior counsel has gone a little bit different, and therefore I felt
no,
that
facts may be interpreted differently, but facts have to remain same.
but some is not being actually apprised before this honorable court, so I feel that like it should be clearly stated, Your Lordship. Annexure 2, Your Lordship, page 14 of my additional affidavit, which was filed on 3rd. 14, annexure 2, Your Lordship, you got it?
The bulky one,
Yeah, the bulky one,
yes,
cabinet memorandum.
yes.
So now how come,
No, any page number?
page number 14, annexure 2.
Yes, cabinet
Your
memorandum.
Lordship, how the case of the petitioner has come about, how the case of the petitioner has given birth, it has started from this, Your Lordship. So we have to see this first, and then we will subsequently come into the case, Your Lordship. Cabinet memorandum, Your Lordship,
Yes,
as to how this upgradation came into existence, Your Lordship. The Cabinet Memorandum on April 2014, Your Lordship, upgradation of government high school to government higher secondary school under School Education Department nominee. The higher.
no,
and-
but this is only cabinet memorandum.
Yes, Your Lordship. So after this Cabinet Memorandum.
Decision was second.
Yes, but we have to see what are the criteria that has been laid out.
Okay,
So it has become apparently very important to.
okay, please
For
read.
this one, Your Lordship, and there was a direction actually from this honorable court also as to how this upgradation has arrived. We have actually taken up this method previously also, Your Lordship, but since there were confusion, the honorable court directed me to put all these things in place. That is why I placed this record.
Yes,
May I read, Your Lordship? The Higher and Technical Education Department by notification so and so dated 1 May 2023 has delinked Class 11 from the state-run government colleges from the academic year 2013-14, which may be seen as at Annexure A. In view of this, the department has proposed for upgradation of 22 government high school to that of the government higher secondary school, Your Lordship. The matter was taken up in the cabinet on 3rd June 2013. The cabinet decided that the education department would initiate immediate action for the upgradation of high school to higher secondary school, and the proposal for the creation and upgradation of the various proposal posts should be routed through the PNAR and the finance department at the earliest. The department should also undertake the exercise of redeployment of excess and surplus manpower within the department for making the upgradation process functional. Annexure so and so. To tide over the admission problem in Kohima, during the academic session so and so, the cabinet approved for upgradation of GHS TM and GHS Sekazu, which may be seen as Annexure C. This has the clearance of PNAR and concurrence of the finance so and so. Now, for the other 20 school clearance has been accorded by the PNAR and Finance Department with condition white UO number so and so dated 3713, which was placed as annexure so and so. The recommendation notification of the state level education committee is placed as so and so. The department also submitted a proposal to the cabinet to select either GHS Chichima established during the 1960s or GHS Chechuzubu Nehru model, which was upgraded to GHS during so and so. Now the important portion. As concurred by the PNAR and Finance Department, there will be no new post creation all the requirements will be met by means of conversion of some existing posts of graduate teacher and primary teacher, so that regular incumbents with postgraduate degree having maximum length of service of 12 years and below may be taken into consideration, subject to fulfillment of minimum qualifying marks of 50%, relaxed by 5% for the backward tribes, with professional degree of B.Ed as first preference. Your Lordship, in order to have minimum expenditure on such conversion, it is proposed that the selection should be made from amongst the senior-most, Your Lordship, senior-most regular qualified teacher. The following criteria is put up for approval. Now, next page, Your Lordship, page 15. Number 1, graduate teacher whose service were regularized by the department till 2012. That means from 2012, this graduate teacher should have been regularized. Primary teacher should be regularized from the year 2003. 2003, the criteria. In order to have minimum expenditure on such conversion, it is proposed that selection should be made from amongst the senior-most regular qualified teacher whose pay scale has already crossed the PGT scale or with par with the scale pay of PGT. The department has also proposed some graduate teacher whose pay scale needs only one increment or notional increment. Therefore, the financial implication is minimum and will be limited to 1 lakh. Annexure Y, the approval of the Upgradation Committee for conversion and upgradation of GT to PGT may be seen as Annexure A. Now, Your Lordship, this is the where criteria has also been laid down that there should be in a regular service from 2012 for graduate teacher. There should be a primary teacher should be regularized from the year 2003 in a regular post, and it will be selected from the senior-most qualified teacher in the the criteria that has been laid on. And there are some of the criteria we can see is also appended on the previous page, Your Lordship, that minimum length of service of 12 years and below, and consideration to fulfillment of minimum qualifying marks of 50 marks, 5% relaxation for the backward, and professional degree of B.Ed as first preference. So these are the conditions, Your Lordship, when the issue of upgradation and the linking, from upgradation of the high school to the highest
petitioners, whether the petitioner have this qualification.
That's why I'm coming, Your Lordship, definitely I'm coming.
They must be having, therefore you upgraded.
That's why, Your Lordship, I'm coming to that. Your Lordship,
Okay.
I will slowly come to that.
Okay.
So after this, Your Lordship, on 19 June 2014, this has already been read out by my senior counsel. 19 June, Annexure 16, page 3. Annexure 3, page 16, Your Lordship.
Yes.
So after this, the minus of the cabinet meeting, it has brought out by this 19 June 2014. Serial number 3 will be very important, Your Lordship. Serial 3 and 4. May I read it again, Your Lordship?
Yes.
The cabinet agreed for upgradation of 266 posts of graduate teacher, primary teacher to the level of postgraduate teacher after identifying the in-service teacher having the requisite qualification. Selection and appointment of the teachers shall be need-based and shall be taken up in phased manner, corresponding to the so-and-so, Your Lordship. So this upgradation, Your Lordship, has to be taken on need-based and in a phased manner. Now, the first batch was taken up in the year 2014. Your Lordship, my learned senior counsel has already pointed out in with petition, Your Lordship. Annexure 23 type copy. Annexure 23 type copy, Your Lordship.
Page number.
The first batch. The first batch was taken up.
Page number.
Page number 23, Your Lordship.
No.
The first batch was taken up in the year 2014, Your Lordship. And in this first batch of upgradation, Your Lordship, and this was being selected, this group was selected taking into consideration the criteria I have already stated before, Your Lordship. So now we can see that by this notification, Your Lordship, by this 7th July 2014, they were being given grade pay of 4,600. Yes, why we have given this 4,600 to the first batch of upgraded teachers is that can kindly come to page 17 annexure 4.
Oh,
Page 17 annexure 4.
of your,
My bulky one here. Got it, Your Lordship?
yes,
Page 17, 2000, annexure 4.
rules.
This is a rule of Nagaland School Education Service revised rules of 2002. So when the first batch of 2014, when the upgradation was done in the 2014, this rule was in place, Your Lordship. So what does this rule says? Your Lordship, page 19, Your Lordship, the relevant portion. Page 19. Let's see the grade P, Your Lordship. The scale P. Page 19, serial 4. Got it?
Yes.
Postgraduate teachers, Your Lordship. It's 6,500 to 10,500. It is on the top, it is on the top, it is stated scale of pay. Now, how do we know that this falls under 4,600? Can kindly come to, and again, annexure page 20, annexure 4A. This is in consonance with the ROP rules of 2010. ROP rules, Your Lordship, 2010. Annexure 4A, page 20. The relevant portion will be page 22. You got it, Your Lordship?
Yes.
Serial number 38, Your Lordship. Serial number 38,
PGT.
PGT, Your Lordship, you got it?
Yes.
So if we see on the last column, the second column is existing scale. It is the same as with the scale pay that is written in the rules of the education, 6500 to so and so. Then on the third column, we leave the pay bin, and the third one, grade pay. Under grade pay, it is written 4,600. So now at this relevant period of time, when the upgradation was taken up, the first phase of upgradation was taken up, this rule was in place, and the PGT were entitled to get this pay, and therefore we have given this pay.
But in 2017,
Yes, that again I will come. Your
this rule was, whether this rule was applicable, because
That's why I
in
will come.
2020, new rule came.
Your Lordship, that's why I will come.
Okay, okay.
So now after that, Your Lordship, I will come to my bulky document with letter, but now I will come to my main again additional affidavit, Your Lordship. So after that, Your Lordship, the second phase, that is the present petitioner.
Yes.
They were upgraded in the year 2020, 5th March 2020, Your Lordship. That is page 30, annexure F of the writ petition, which my senior learned counsel has relied upon. Page 30, annexure F.
Yes.
So now we can see that like now the second batch of upgradation was taken up in the year 2020. Now, right before that, now we want to come to the finance concurrence, how the finance concurrence and how the finance has given a concurrence, Your Lordship. The first finance concurrence was given on page 20. Annexure copy will be on page 25. Finance concurrence 26, page 26, annexure D of the writ petition.
Yes.
The finance department, Your Lordship. The concurrence was given on 1/6/2016. Here, the finance has given a concurrence that it should be given 4,600, Your Lordship.
Yes.
So till this time also, Your Lordship, the rules of 2002 is in place. So no problem. Now, secondly, the finance concurrence, which was given on page 28 annexure E of the writ petition.
Yes.
If you see on the line, here also 4,600, Your Lordship. The grade B is being given 4,600, and the concurrence has been given on 2012-2017.
Yes.
Now, I would like to draw your attention to the rules, Your Lordship. I
Where will I get rules?
I'll just show you them.
In your first,
In my additional.
second one.
Yes. Okay. To be annexure 57, Your Lordship. Annexure 57.
Page number.
On the last side. Nagaland School Education Service Road 2017. Annexure 57, 291. You got it, Your Lordship. Page 291, annexure 57.
Yes.
Nagaland School Education Service Road 2017. Oh, Your Lordship, original copy.
No, the copy is there in,
Yeah, it has come into official gazette on 29 November 2017. Now, why I am showing this is, Your Lordship, it will become very much relevant, Your Lordship. That's why I am showing you, Your Lordship. Nagaland School Education Service Rules came into existence on 29, it was amended on 29 November 2017. From the day it was published in the official gazette, Your Lordship. Now, as per this amended rules, Your Lordship, we can see in page 299, the service rules has been amended, and how it has been amended, we can see in serial number 9 and 10. Now, this PGT has been categorized into two, Your Lordship. Serial number 8 and 9.
page 290.
Page 292.
290.
292, Your Lordship, in my affidavit.
Yes, serial number.
Serial number 8, serial number 9, Your Lordship, serial number 9. Sorry, serial number 10, my apology. Serial number 10. Now, PGT has been categorized into two, Your Lordship, by this amendment, Your Lordship. Senior PGT, it will come under junior grade 2, and PGT, Your Lordship. PGT, junior grade 2. Now the grade pay, the senior PGT of grade 2 is getting 4,600, and the PGT of PGT is getting 4,400. as per the amended rules of 2017. And has been brought out again in consonance with the ROP rules, Your Lordship, ROP rules of 2017, Your Lordship. I have annexed, Your Lordship, 295 annexure 58. Relevant portion will be pitched last page, 297.
Yes. Serial number?
Lordship, I think it will be proper if we can go through this one, the original one.
No, the copy is there. You just tell me the serial.
So, Your Lordship, the senior, the PGT, Your Lordship, the postgraduate teacher, their grade P is 4,400.
Where? It's serial number. There is a table. In that table, there are serial numbers.
46 and 47, Your Lordship.
Senior postgraduate teacher and postgraduate teacher.
Senior postgraduate teacher will be 4,600. Postgraduate teacher will be 4,400.
Okay.
So now this rules of the Nagaland school education has been brought up in consonance with the ROP rules, Your Lordship. And the ROP rules has stated that the grade pay of senior postgraduate will be 4,600 and the postgraduate teacher will get 4,400. Now, let's see the when it has come into existence, the ROP rules. ROP rules has also come on 16 December 2017. 16 December 2017. Now coming back to our finance conference, finance concurrence dated 20.
From where you are saying that it came into?
You look at the first page 296. On the top, right top.
Oh, yes.
16 December 2017.
Yes.
Your Lordship, now let's refer back to the finance concurrence. Finance concurrence was given on 2012-2017.
22.
Yes, 2012, December 2017.
After this ROP.
Yes, and this was on 16th and the other is on 29 November. So there's a difference of 1 or 2 days, or maybe 3 or 4 days in the differences, where this route has come into place and where this concurrence was given. And therefore, during the pendency, when this case was filed, and on going through the petition, we find that no, the rule should be in place. How come the finance has given this concurrence? And therefore, before filing an affidavit, we sought clarification to the government, to the finance, to give a clarification as to how this concurrence has been given in violation of the rules, of the statutory rules. And therefore, we, by letter dated, Your Lordship, now to my main affidavit. Page 13, annexure 2. Page 13, annexure 2.
Yes.
We wrote a letter to the Commissioner Secretary Government of Nagaland, Department of School Education, SCRT Nagaland. Reference number is finance concurrence, which was being given, and we requested to initiate steps. Shall I read out, Your Lordship? For the convenience, request for initiating steps with the Finance Department for issuance of clarification with regard to the grade pay of postgraduate teacher under the Department of School Education. With reference to the subject above, please note as under. The service of the Department of School Education is governed by the Nagaland School Education Service Rule 2017. The rules of 2017 came into effect from 29/11/2017. Mention may be made that in the previous rules, the grade pay of postgraduate teachers was provided as rupees 4,600. However, by the existing rules governing the service of the department, that is the rules of 2017, the grade pay of postgraduate teacher have been provided as rupees 4,400. Relevant page, I have already apprised the court. By the concurrence dated 2012-17 mentioned above, issued by the Department of Finance with regard to the upgradation of 115 posts of PGDT to the post of postgraduate teacher, the grade pay of postgraduate teacher have been shown as 4,600 as opposed to the existing rules of 2017. As per the existing rules, the department have been allowing the postgraduate teachers to draw a grade pay of 4,400. Against the same, a group of teachers have approached the Honorable Court by filing the present petition, Your Lordship. It is now necessitated that a clarification be issued so as to apprise the Honorable High Court about the error that occurred in the issuance of the finance concurrence above referred. In this circumstances, it is requested that appropriate steps may be initiated from your end towards the finance department for issuance for a clarification dated corrigendum regarding the error so that the same can be placed before the Honorable High Court enclosed copy of the concurrent above. This is for your kind information and necessary action. Now on the next page, Your Lordship, Annexure 3, I have enclosed the notings, Your Lordship. It was processed. This is regarding grade pay in respect of postgraduate teacher as explained in the foregoing notes. Page so-and-so may examine concurrence accorded at page so-and-so and issue corrigendum rectification on the grade pay as per Service Rule 2017, flagged so-and-so. Now on the next page, page 15, Annexure 4, Your Lordship.
Yes.
The finance gave a clarification. The finance department has examined the case submitted by the school education department and conveyed the following. Any appointment made to the post of PGT after the coming into the effect of the Nagaland School Education Service Rules 2017 shall be governed by the provisions, guidelines therein. Concurrence of the finance department in respect of the pay level of PGT vice so-and-so stands superseded with the coming into effect of the Nagaland School Education Service Rule 2017. So now, why did we take this step? Because while going through the petition, we find that a concurrence has been taken inadvertently, maybe, because, Your Lordship, we can see the debt. The school education rules has come into place, the ROP coming into place, and the concurrence taking into place. There is hardly a difference of 5 or 6 days. So maybe there was a gap of communication. Maybe communication gap was there. Maybe because of that, this concurrence might have come about. And therefore, since this concurrence was not in consonance with the rules, amended rules, therefore we sought for clarification and the finance clarified accordingly. And after we got the clarification, we have filed this petition before the Honorable Court, so that this Honorable Court can also come to a judicious conclusion. With this, we have not done this to develop the case, Your Lordship. We have done this so that my Lordship can able to come to a judicious conclusion. Now, after this, Your Lordship, after the rules has come into place, Your Lordship, the school education has also brought up one notification. Can we come to my page 16, Annexure 5?
Yes.
Dated 23 August 2019. Got it? May I read, Your Lordship?
Yes.
On the recommendation of the screening committee, the Department of School Education hereby declare the following graduate teacher, primary teacher as successful for upgradation to the post of postgraduate teacher under the government higher secondary school. The above selection is so-and-so. Now we see the name, and after that, Your Lordship. This is, Your Lordship, with regard to upgradation of the post. No, I will not refer this one, Your Lordship. I would like to refer to the notification brought out by the school education right after the rule has come into place. 7 December 2017, page 25, Annexure 10, Your Lordship. Annexure 10, page 25.
Yes.
Consequent upon the adoption of Nagaland School Education Service Rules 2017, and in the interest of public service, the Governor of Nagaland is pleased to order the restructuring of the Department of School Education at the Directorate and subdivision level. The categories and the numbers of posts, as well as various categories of teacher, along with the pay bands and grade pay, with the number of posts, both temporary and permanent, shall be indicated in the Schedule 1 to Nagaland School Education Rules 2017. The following posts shall be upgraded. I will not look into that. The operative portion 13, para 13. All the teachers who were appointed prior to the issue of the Gazette notification of the Nagaland School Education Service Rule 2017 on 29/11/2017 shall continue to enjoy the respective pay bands and grade pay. Only those teachers who are appointed after publication of their revised service rule, only those teachers who are appointed after the publication of the revised service rule shall be given the revised pay band and grade pay of their respective cadre.
Yes.
Now, Your Lordship, after the rule came into place, to supplant, again, Your Lordship, the school education also came out and brought out this notification. Yes, Your Lordship, my Senior Learned Council has already said that the rules, if it's not reflected on the other, that it is retrospective, it will always be prospective. Very true, Your Lordship. I agree to that law, Your Lordship. Now, how did the petitioner got appointed, upgraded? When?
Yes.
Did it got upgraded up before the rules or after the amended rules, Your Lordship?
In 2020.
In 2028. That is much after the 2017 rules came into place. Now, which rules shall we allowed them to play now, Your Lordship? Now they are saying that they should be getting 4,600. And now, as per the rules, 4,600 is according to the senior PGT. They are upgraded to the PGT, Your Lordship. Now, if they are sitting for 4,600, then they should be promoted to the post of PGT, senior PGT, not PGT, Your Lordship. Your Lordship, and therefore, Your Lordship, the contention of the government is that, Your Lordship, since their appointment, Your Lordship, their upgradation was done in the year 2020, that is much, much after the amended rules of 2017 came into existence, and therefore their grade pay of 4,400 has been rightly granted to them, and no discrimination has been meted out to them. And what about those first batch of upgradation? How were they given? They were given also as per the rules, as per the prevalent rules. At that period of time, we didn't just randomly give them, but it was as per the rules of 2002, which was prevalent at that period of time, at that relevant period of time. And now the petitioners who were appointed, who were upgraded in the year 2020, what was governing them? Their service conditions were governed by 2017, and therefore, rightly, we have given them grade pay. Now coming to my learned senior counsel submission that their pay should be protected. Yes, their pay should be protected. How? When they were promoted, before they were promoted, upgraded to the postgraduate, their service in that previous post, their pay should be protected, so that when their post will be upgraded, it is known law. It is a settled law. My senior counsel also knows about that. The previous post, prior to the upgradation of the post, prior to upgrading to the post of postgraduate teacher, the post they were holding, what pay or service benefits they were supposed to be protected, will be protected. And therefore, my senior learned counsel has given a statement that we are taking two stands. One said that on the other hand, our pay should be protected. On the other hand, it should be 4,400. We are rightly saying that it should be 4,400 as per the amended rules, but their pay will be protected where their past service, serving as a graduate teacher or as a primary teacher, all those years, all the increments that have been incurred, all the past benefits that have been incurred, it will be protected. Their pay will be protected. That is what the intention of the government is all about, nothing else. Now, Your Lordship, I would also like to Come to my documents, one document again, Your Lordship, on the bulky one. Why I have brought all these documents on record is that, Your Lordship,
Sorry for interruption, Lordship. At 4, Lordship has fixed another matter.
We
I
will,
not know how long my learned friend will take.
we will take up that matter again, continue with this,
hold on.
call that matter.
It will take about 3 minutes only. We are aware of the result of the writ appeal, but better to finish up that. Not know how long my learned friend will take. Will it take long? Not all are equally important, but then since the time has already been fixed.
He has done this intentionally to break your flow. Yes,
For admission, item number 54.
yes.
Before my learned friend Shukri submits. This very, I should say it is unfortunate.
Video part also video on model. From that side only.
Some disturbances have
May I please lordship? Am I audible?
You are audible but not
not
visible.
visible. But
Yes.
yesterday
from
I have allowed you to speak first. Today,
lordship.
allow me to speak first.
Lordship.
Adverse to you.
Okay, okay.
I will just say a word. Considering the timeline involved in the case, I was so conscious, even I was counting hours. But this morning when the writ appeal was listed, my client, she appeared in person along with her father.
What is the writ appeal number?
Lordship, the writ appeal number is 260 of 2025.
She made the submission in person, she appeared. And prayer that next time will be required because they have received the writ appeal memo only last night. That was the submission made. In view of that, the Honorable Court was pleased to grant 2 weeks' time.
Appellate court.
Yes. So in the meantime, since time has been sought for by the petitioner for 2 weeks' time, it was imbued order was stayed by the appellate court. So in view of that, the present contempt petition also goes along with that because everything will be decided by the appellate court.
No,
Yes.
what will happen to the contempt petition? Whether it will be dropped or it will be kept in abeyance?
Admission will be subject to the outcome of the writ appeal. That is the order passed in the appellate court, and then the one seat has been reserved.
No. Okay, but stay has been granted to
Yes.
granted.
Yes.
So what will happen to this contempt petition? It has to remain in abeyance.
It is already closed because in view of the observation made by the appellate court.
No, stay is interim stay only. It has not been finally decided. Suppose appeal is decided in favor, then only this contempt petition,
Yes.
it will.
Yes, contempt was already committed. That is why I was making a submission that.
My query is, what will happen to this?
Lordship, because only the interim. So even if the contempt is dropped at this stage, the petitioner has the liberty to come again for contempt. So it won't be any problem.
Lordship,
Yes,
since the court stayed judgment and order passed by your lordship, the contempt does not survive.
yes, Mr.
I've already made my submission, it stated that it is the duty of the petitioner to bring it to the notice of the court, whether there is contempt or not. So once I brought it to the notice of this honorable court, it is up to the honorable court and the contempt.
Heard. Heard Mr. C.T. Zamir, learned senior counsel, assisted by Mr. I. Im Chen. Also heard Ms. V. Sokri, learned additional AG, as well as Mr. Imti Im Song, learned additional AG appearing through video conferencing, as well as Mr. Imti Im Song, learned additional AG, who is present in person before the court. It is submitted by learned additional AG that the appeal preferred by the state respondent, which was registered as that in the appeal preferred by the state respondent, which was registered as writ appeal number 260/2025, the appellate court has stayed the operation of the order passed in the writ petition by this court, in respect of which this contempt petition has been filed. It is submitted and submitted at the bar that in view of the stay granted by the appellate court, this contempt case is liable to be closed. Accordingly, this contempt case is closed.
Lordship, the
Yes.
presence of N. Angami and S. Seye may be recorded, Lordship.
Who's
The presence of N. Angami and S. Mere also may be recorded in the order, Lordship.
okay.
Lordship. Much
Also,
obliged, Lordship.
also heard Mr. N. Angami, learned senior government counsel, as well as Miss S. Mere, learned government counsel, senior government counsel, appearing for the contemners.
Yes, Lordship, for the contemners. Yes,
For the contemners.
yes.
All right.
Much obliged, Lordship. Much obliged.
Yes, Miss Livika. Yes, Mr. Viru.
Worship, good to mention the last item, item number 55, also. Due to positive of time, Worship. It will not be possible to take up this matter, Worship.
Heard Mr. M. Vero, learned counsel. What is the item number?
Item number 55,
Item number 55. M. Vero, learned counsel for the
petitioner.
petitioner, as well as Miss S. Mere, learned senior government counsel for the respondents, for the state respondent. The hearing could not be, the hearing of this case could not be taken up due to paucity of time. Hence, let it be listed
Service, Worship.
after 3 weeks on a date to be fixed by registry.
Worship, there's an interim law.
The interim order shall continue till next week.
Much obliged.
So.
Yes.
Lordship, all of the cases that your Lordship, yes, the upgradation was taken up, it was.
What pay the petitioners were getting before their upgradation?
Before the upgradation to
In
the
twen-
postgraduate, they were serving either as a primary teacher or.
So it
as
was
a
much
grade
less than
teacher.
4,600.
That should be. your Lordship.
Yes.
Whatever
So
benefit, it will be protected.
now what they are getting 4,400.
Yes, your Lordship. They are, as per your amended rules, they are getting 4,400.
And they are
Yes.
claiming 4,600.
Whereas the first batch who have been upgraded, your Lordship, the first group in the year 2014,
14.
they got 4,600. At
Because
that,
rules and
as per-
ROP prescribed for that.
4,600.
At
And
that time.
that period of time, it was only PGT. And that
Okay, because 2017 rules
has categorized.
categorized into two categories.
PGT, senior PGT, both grade 2, but it has categorized in accordingly, your Lordship. So PGT will be getting 4,400 and the senior PGT will be getting 4,600. So now our contention is that. Now, the one question may also arise, my senior counsel may say or may not say, your Lordship, but why we have actually put all this appointment errors, regularization, everything before your Lordship is because, your Lordship, at that relevant period of time, when the upgradation took up the first phase, none of them were eligible at that point of time. So they were not. All of them
Why they were not eligible at that time? It was on the need base.
It was on need base, Your Lordship, it was on phase wise, as well as the senior most, there's a criteria as I've already
They were
read out in
not,
the
they
first.
did not attain that seniority.
Yes, and if we can see all of them, how they were appointed on ad hoc. Date of regularization, we can see how, when they have obtained B.Ed and the service confirmation, everything is written here, Your Lordship, on page 23, annexure 4B. Annexure 4B, just for reference only, Your Lordship, yes, for reference.
Of your affidavit.
Of my additional affidavit, Your Lordship, the bulky one. Page 23, annexure 4B. Your Lordship, I have summarized it like
Yes.
and the documents are annexed for it, Your Lordship. So we can see the date of appointment, Your Lordship, they were not, all of them were on ad hoc, the present petitioners, and the date of regularization I have entered, documents are also enclosed. The year has been mentioned, some we cannot find the date, so we have mentioned only the year when they obtained the B.Ed degree. And also we can see from which date or year they have got postgraduate also, postgraduate degree also. So everything is written here, Your Lordship, and the documents are substantiated, Your Lordship. So at that relevant period of time, 2016, first-wise, need-based, they were not eligible. And even those persons who got it, they got the grade pay of 4,600 as per the relevant rules of 2002, that is 4,600. Now coming back to our present petitioner, Your Lordship, as I have already submitted, Your Lordship, they were appointed in the year 2000, Your Lordship. And that was much
2020.
2020, Your Lordship. That is much after the rule that come into place, and therefore, Your Lordship, their service rules will be governed by the rules of 2017, ROP rules of 2017, and so we have rightly given them the correct grade pay, Your Lordship. Now, I would like to cite some citation, Your Lordship. First is, Your Lordship, my Lordship will say that like this concurrence, yes, put lots of emphasis on the finance concurrence, Your Lordship. But even if we take that submission also, the law says that it will only be executive in nature, and the executive nature cannot override the statutory rules. It has been last 3 days, my learned senior counsel has been consistently banging on that, so I don't need to stress much on that. But if we go in light of the submission of if we are to go in light of the submission of my senior counsel, then, Your Lordship, the notification, Your Lordship, it is only an executive in nature, Your Lordship. So it cannot supersede the statutory rules. That is my first point. And in that, Your Lordship, I would like to cite. Your Lordship, here the fakes are different. I'm just taking out the principle, Your Lordship. Only relevant portion. I'm sticking to the principles only, Your Lordship.
Which para?
Para 27, Your Lordship. Just principle only. Executive instructions which have no statutory force cannot override the law. Therefore, any notice, circular, guidelines which run contrary to statutory rules cannot be enforced, Your Lordship. Here the facts are different, Your Lordship, but I'm taking on the principles that no guideline, circular, or notification or whatever cannot, which runs contrary to the rules, cannot take precedence, Your Lordship.
Yes.
Yes, another thing, Your Lordship, this judgment has been passed by this division bench, Your Lordship, by my Justice Ajit Borthakur and Justice Kahetosen, Your Lordship, in division bench. Here, case is a little bit similar, Your Lordship. There was an advertisement, and as per the advertisement, the grade pay was they were supposed to pay they were supposed to get the grade pay of 4,200 when the advertisement was issued. But meantime, the rules of 2017 came into place, as well as the notification which I read, the notification brought out by the school education, it was in place. So by that, Your Lordship, by the amended rules of 2017, the grade pay was downgraded to 3,400. So now here was also the same condition, Your Lordship. They say that they should be getting as per the advertisement. But the court has said no. And there's so many judgment that has been clearly and like very elaborately discussed. And I will not look into all the things. I will just place this before Your Lordship. It's almost similar to our thing. There was an advertisement say grade pay will be 4,200, but they got the result was declared, they were successful, but they by the time they were successful, this amendment rules of 2017 came into place. And so they were given the grade pay as per the new amended rules of 2017. The petitioner were agreed by that, and they came before this court. Before the single bench, it got dismissed. Again, the petitioner went for appeal, and it also got dismissed. So this lordship can get great light again from this judgment, Your Son. Your Lordship, now my senior learned counsel, my last submission will be, my senior counsel has saying that the rules, now they should be getting 4,000. They should be getting 4,600 and not 4,200. If there's at all agreed, they should challenge also the rules, but that has not been done. If they at all, now they are saying that they should be getting 4,600, which is equivalent to the rank of senior PGT. Now, if you go in that line, then they should have challenged the 2017 rules. They should have challenged the appointment also, Lordship. That has not been done, so Lordship. So with this, Your Lordship, I will leave it to your jurisdiction. This judicious mind.
I will take about 10 minutes of Lordship. I will start from the last. My learned friend has made a submission in
No.
conclude her submission.
On what basis you are claiming and that protection of 4,600?
Yes, under strength of the government order.
Which order?
There are two
38,
orders. One is
38
in
and 30.
page 31, one is in page 38.
38 and
Order dated 5/3/2020. This has the relation of the cabinet approval of pre-service roll up 2017.
but this notification is contrary to the provisions of rules which were in force.
That is what I have been submitting during my submission. Government is trying to develop their argument, thinking on the service role. They want to rectify and correct their mistake by thinking in the service role, but see the basis. I will come to that.
Now,
First, Lordship.
no, before that, one more query. This you were appointed, your appointment date is different appointment dates.
Appointment date, Lordship.
Now, upgradation.
Upgradation is page 31 and 38. Page
So
30,
upgradation date is 5th March.
2020.
Before that, you were getting lesser pay.
6,000.
Lesser than 4,600.
4,600.
Before that, before your upgradation.
During that time, we were only graduate teachers. So
No.
we will get the graduate teacher base.
So it is obviously lesser.
Yes,
Now, after your upgradation, what pay you got?
4,400. That's why we are before the Honorable Court.
In spite of this notification?
Yes. Now, first thing first.
No, whether government issued any rectification.
No. That's why Lordship kindly come to, since, let me reply Lordship.
No, since 2020 to 2025, you are getting salary.
Yes,
What salary you are getting?
based on the 4,400.
400. Okay.
Page
And your
38.
basis is 5th March notification.
Yes,
Your main submission is that it has concurrence of all the line departments.
yes. And basing on the cabinet decision of 2014, 19 March, 19 June, sorry. So kindly come to page 38 of the petition. My learned friend has treated it as an appointment, but this is not appointment, but this is upgradation.
Yes, it is upgradation.
Paragraph 4, Lordship. Page 38.
Yes.
These issues with the approval of cabinet, right, dated 19 June 2014, and is ex post facto clearance of pioneer department and the concurrence of finance department. Here, concurrence of finance department is 1/6/2016.
But that is also an executive function. The concurrence is given so that final decision may be taken.
Yes, and kindly come to page 30. No, page 26. So this has a connection with page, type copy is at page 27. First paragraph, Lordship. Finance Department. The proposal has been examined and agreed for upgradation of 48 posts of PGTs, GT to the post of postgraduate teacher in the pay scale of so with grade pay of 4,600. Clearly it is mentioned. Basing on this, upgradation order has been issued. By relying on this orders of the finance concurrence,
Then I have a query for Ms. Livika. The appointment, the upgradation order mentions 4,600, rightly or wrongly? On the basis of this upgradation order, whether any payslips were issued?
2020 does not talk about 4,600. It talks about pay 1111, pay metric 11. 11 talks about 4,400. Your Lordship. We have to be very clear on that. 4,600 was only mentioned in March 2014, the first page, and the concurrence dates. But on the appointment order, on the upgradation appointment order, Your Lordship, it is mentioned 4,400. There is not a whisper about 4,600. They were given a pay level of 11. Pay level 11 is 4,400. Your Lordship.
a submission was made, the role has not been challenged. Now, under point, one simple answer, Lordship. This grade pay is not only for the petitioners, it is for the entire department of the school education. So they cannot challenge.
No, before you complete your sentence, the notification at page 30
Yes,
as well as at page 30A, where does it speaks about 4,600? It mentions only
it's
pay level 11.
It's 4,400.
Pay level 11.
Yes.
Pay level 11.
Pay level
11,
is
which according to ROP, the equivalent earlier pay is 4,400.
4,400. But
So on what basis?
paragraph 1 cannot be read in isolation. It has to be read with paragraph 2. Put the orders.
But both the order decides to give you 4,400 only.
Yes, yes.
Your submission is that finance concurrence was of 4,600.
Yes,
So you are harping on the finance concurrence mainly.
cabinet decision, 3-year approval and the finance concurrence.
But the notification.
And government order also says that all past service benefit shall be protected.
But in the past, you never got 4,600.
Yes, maybe.
So
But-
what protection you are seeking?
Finance
Pay
department has
protection,
totally
the
concurred.
concept of pay protection is, to my understanding, if I'm wrong, correct me, that if you are getting a particular pay, then if you are promoted or transferred or shifted to some other job, if pay protection is there, you will not get lesser pay than what you were
Yes.
getting earlier. So even if pay protection is granted, you have to show that you were getting 4,600.
If there is any sort of confusion, then kindly come to page 43 of the petition again.
43.
What the government order says and what they are doing. This is a document issued by the department, not by the petitioner. This is the document of the respondents. Page 43. Incumbency list postgraduate teachers, PGT of government higher secondary school, 2020-2021. Here, Lordship will find the pay level in the middle of the page. Category of post, scale of pay, pay matrix level. Has your Lordship got it?
Yes. Now, what is this? This is the incumbency
Incumbency
list.
And this is a document of the government, which shows the postgraduate teachers, what is their status, what pay level they are enjoying. See, serial number 11, Akunu Dasi,
Yes.
petitioner number 38.
Yes.
What pay level she is enjoying? Pay level 12, that is 4,600. This is not prepared by me, this is by the government.
No, but it is prepared on what basis? Because by the notification which upgraded your services to postgraduate teacher, it mentions pay
11.
level 11.
Pay level 11.
And 43 is a mere compilation.
Yes. So all of us were shown pay level 12.
Your Lordship, there were in this regard also, Your Lordship, there was a error, Your Lordship. And so we rectified this one also. There was a rectification of Your Lordship. Because it has correctly.
All
the
rectifications have been
resident-
done after filing the
No, not
petition.
filing. Before the filing.
one
see, there
photo was issued in 2019. Otherwise,
No, but are you basing your case on this incumbency list also?
yes. In the incumbency list of 2020-2021, that is much up to the service role. And pay
No,
level is shown 12.
Does it gives any sort of right, any kind of
If we are
Notification.
to rely on the government orders. Otherwise, government orders cannot be just for the purpose of throwing to the dustbin.
Okay. Anything else?
That's all, Lord.
Heard Mr. C.T. Zamir, learned.
I have two citations, Lord.
Yes.
One is Mahendra Singh Gill's case. Whose government has tried to do that. Paragraph 8, Mahendra Singh Gill's case. 1978. One is 60.
What it tried to develop? The notification at page 30 and 38. By
If we look at the decision of the cabinet, pay near, finance, government orders, All this shows that petitioners are entitled for a great pay of 4,600. But by filing affidavit in opposition, government is changing their stand.
In
Taking a
Mohinder Singh
contrary
Gill,
stand, taking
Mohin-
on the service road.
in Mohinder Singh Gill, which para you are relying?
Paragraph 8,
Para 8. And the other case?
2017, 9 ACC 397. This is under pay parity. Paragraph 28, 23, 26, 27, and 28.
You are seeking parity with the 14 batch.
Yes.
Good. Heard Mr. C.T. Zamir, Learned Counsel, Learned Senior Counsel, assisted by Mr. I. M. Chen, Learned Counsel for the petitioners. Also heard Miss Livika, Learned Government Counsel, Senior Government Counsel, Learned Government Counsel, appearing for the state respondent. Hearing concluded, judgment reserved.
Lordship, in view of time constraint, I have not responded to one point. My learned friend has referred to the additional affidavit. To that, I have replied in paragraph 4, only that much. Additional affidavit, the argument which has been advanced by my learned friend, basing on the additional affidavit, my reply, Lordship will find in paragraph 4 of my reply. Objection to additional affidavit of respondent number 1 to 5. Paragraph 4.
Lordship, they have given an
There-
objection only with regard to
With regard to the-
obtaining of BX, but we don't have any problem with that.
In all these things.
Okay.
We don't have any problem with that.
The-
We give them,
Other page of 2014, many of them were not possessing PH degree at that point of time, upgradation, at the time of upgradation. That point was taken by the government.
One query. On what basis this categorization of senior PG?
Your Lordship, that is an amended rules. Lordship.
No, how you will promote? How you will select? On the
Your
basis
Lordship-
of seniority? It is provided in the service.
In the schedule, it will be mentioned in the schedule, how they can be promoted, Your Lordship,
Okay.
on the schedule.
And these petitioners are not eligible or what?
Now, if they are seeking for 4,600, then it should be
Senior.
it should be senior PGT. And what is the criteria for promotion to the senior PGT? It will be written on the schedule, Your Lordship. It's clearly written.
Okay.
Your Lordship, my submission can kindly based on the two rulings, Your Lordship, and most importantly on the division bench, Your Lordship, because many issues, because it's similar to the case, Your Lordship. So that may be looked into. The rulings that are.
That is with regard to the advertisement, pre-appointment, not the application. So the facts are different.
But don't make the file bulky. Use 2 or more files. And keep the citations in a separate file.
Your Lordship, shall I take it to the schedule?
You take the original one. One more original.
You could, after the judgment is delivered, I can take it, Your Lordship. But
No,
I can take it,
you
the
take.
schedule one.
Which one?
Schedule like as to how this, the senior can be promoted, senior PGT can be promoted, or the PGT can be.
Okay.
Shall I keep it with you or Your Lordship?
No, you can, there is photocopy of the rules.
That portion is not, photocopy.
Then you give it to me. You take it back after the judgment.